ಊಟ ಫ್ಯಾನ್ ಯಾಕೆ ಇದೆ ಸ್ವಲ್ಪ ಹೊತ್ತು ಹಾಕಿ ಆನ್ ಮಾಡಿದ್ದೆ
Just ಮಾಡಿದ್ರು ಮೆಸೇಜ್ ಕೊಡ್ತೀವಿ ಪ್ರೆಸೆಂಟ್ ಟೈಪ್ ಮಾಡಕ್ಕೆ Yeah. Yes, sir. Yeah. ಗೊತ್ತಾಗಿಲ್ಲ ಎಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಸಾಲ ಮಾಡೋದು
ಯಾವತ್ತಾಗಿದೆ ಸರ್? ನೋಡ್ತೀನಿ ಬಿಡಿ.
Yes, secular. But one matter for admission, because there was a, against the order of the CAT, they have, the contempt has been filed in contempt, that the direction issued to comply the order. But I think your lordship may have it on. The contempt was filed, well, there is, they have already issued a direction to comply the order, and otherwise they present.
When was the main order passed, Mr. Sheikh?
Well, I think it was. I have filed it January, my lord. The OAC, the writ petition was filed in January.
Who has filed it? You have filed it?
Yes, I have filed it.
When was the original order passed?
Well, that is in the 24.
Which month?
Exactly. I don't have the date.
You also
Any
delayed.
that I am not seeking tomorrow. Saturday it may be taken up. I am not. Friday or Saturday, any day convenient to your lordship.
Just take it. Objections cleared?
Well, objection has been cleared. One objection was, they said we had to mention as annexures A and R1, R2. Well, I said the High Court rules prescribes we have to mention it annexure A, B, C, D, E. They said what I have filed in the reply filed in CAT, it was R1, R. Well, that is not the rule of the High Court at all under the rules.
Other than that, how many?
That's all other objection I have complied.
Just say, just take it. When is the contempt listed?
I think, but on first of the Saturday it may be have it, I said.
Yeah, just asking, when is the contempt listed?
First of April, they said by the time you have to report to the compliance order, they said.
All right, we'll have it next week. Just give it next week.
My lord,
Yes, Mr.
kindly.
Tiwari. Yes.
My lords, this
Much.
commercial appeal, my lord, was partly heard by my lords at last month.
Which is that?
This is regarding the trade dress dispute, my lord. And what has happened is.
Oh,
Yeah.
that one.
Yeah.
Who is the other side?
My lord, I appeal, my lord, for the appellant.
Have you informed the other side?
Yes, they are appearing.
My lord, I appeal for the
Yes, now
appellant.
what is the?
My lord, the issue is that we have discovered a fraud has been played not only before the court below, but also in the statement of objection that they have been deliberate misstatement. We have got all the material. The issue, my lord, is
Is the date we have given?
my lord is given in 8th. The difficulty, my lord, is 31st March. The disbursement has to happen with the horticulture department. And otherwise the fund is lost and the farmers will also suffer. My lord, any date, either this week or next week, my lord.
Who is the other side? Otherwise, appropriately should have been an early hearing.
Earlier application has also been filed.
Now, who appears for the?
My lord,
you
I
are the
appeal for the
respondent?
appellant, my lord, in the
We
present.
are the appellants, my lord.
Appellant. Who is the
I appeal
respondent?
for the respondent, my lord, in the present case.
Now they are seeking an application.
Yes, my lord, they're filing
So we will
application.
list this
sir.
application for early hearing.
My lord, I just want to file my objections on record because they have made allegations of fraud against me. So I want to place my objections on record, my lord.
That we. No, there is an early hearing application which is filed.
Yes, my lord.
So we will list that application.
Yes, my lord.
Okay?
Yes, my lord.
We'll list that application. We will see what are the pleadings on this fraud. Just have it tomorrow.
Much obliged.
Yes, Mr. Tiwari. Okay, you should go ahead.
Oh, this is a last student, he was not allowed, he was not, the examination fee was not taken and not allowed to take examination in
the-
2020.
What is the nature of that petition?
Petition, it was a dismissal in the writ petition and.
Is it an appeal, writ appeal?
Appeal,
Which year?
which to 23.
Just take it, man. What is the urgency?
The boy is still, is in the second year, he was not allowed to take examination since 2020 itself. It is,
When are the exam now?
exam will be there in the paper.
No, which day? Do you have the
Date
schedule?
I have to get. Examination of all the semesters, all the 5 semesters.
Have you filed any application?
No.
File an application. See, your prayer is different here. Must file an application for appropriate relief and mention that application. We'll get that application listed. Okay,
IA out.
that's right. Yes.
Commercial appeal, my lord. A small issue, my lord, is the inducement of contract, my lord, the breach of contract, the inducement, my lord, that is small. Matter was heard for some time, my lord, before this court.
Is it 37?
No. So.
Commercial suit?
Commercial appeal.
Okay.
I am non-suited, my lords, for the reason that there is no cause of action made out against the respondent.
Under 7.
Now, my lords, the issue is, my lords, inducement of contract by my.
Is it a pending matter? Have you filed any early hearing?
Will be listed today, my lords. It's not listed.
Pardon?
Date given matter, my lords. Today is a date given matter.
It's today's date?
But it's not listed today, my
No,
lords.
no, we will see that. What is the name? What is the number? We'll just check up that.
My lords, unfortunately, my lords, date has been given as 19th of July. Matter was heard in February. It was supposed to be on 19th of March. I think there's some mistake in the order sheet.
Do one thing, Mr. Tiwari, file an early hearing.
Yes,
Okay, file an, so date is 19 July now. You're right, can be an error. File an application seeking an early hearing, inform the other side, we will allow. Okay, yes.
Commercial appeal matter, my lord. Execution proceedings are in April 7th.
Is it a pending appeal?
No, fresh matter, man.
Fresh matter.
Fresh.
Now, when is the execution?
April 7th.
April 7th. Now, that's the objections clear?
Objections is clear. I have
All-
served the copy of to the respondent also.
Aviator there?
I have served them the copy.
Yes, sir. You tell the date also, inform the date also. to the
Obliged,
aviator. Just 1 minute, ma'am. Let's be through with this. Just one, yes. Huh. File an early hearing. It's a pending matter, no? File an early hearing. Okay? Yes. Pending matter, file an early hearing. You file early hearing, just take it there. What is the urgency?
They are going to retire in next 2 years.
Doesn't make any difference. You still get it. Promotion, just take a date, give a date, man. Give a date. Yes,
First matter mirrored. Root for partition did mirrored.
first,
RFA.
First appeal mirrored.
what is that? RFA is not here. Huh. Which year, ma'am? Yes, pending matter. What are you mentioning?
No compensation has been provided. It was acquired in the year 1981, same was for trust purpose, but then it was converted and used as commercial lands. The appellant herein had also.
Now, what are you mentioning? Are you mentioning for listing? You file any application? File an early hearing. It's a pending matter, file an early hearing.
One matter, my lord, the appellate during the pendency of the appeal, my lord, died, my lord. I filed application to bring the LRs on record. That may be put up, your lordship.
Take it, but
One
you have
more.
informed the other side?
My lord,
Have you informed the other side?
I will inform, my lord.
You have to inform.
No,
the
I have
date.
served the copy on them, my lord. Then I filed the appeal, your lord, application.
You have to give the date also to them so that they are present.
I will inform, my lord. If the
just
date is
inform.
given, I will definitely inform.
Just give
My lord,
it.
one more matter, my lord, fresh matter, my lord, which was filed, my lord. The respondent plaintiff filed a suit for permit.
Just 1 minute. Let's be through with this.
Oh, 1-4. 1-4, yes, sir. I will.
Ma'am, ma'am.
Yes, sir.
Just change. You will have a different date.
Yes, your lordship.
Yes.
One more matter, my lord. The respondent plaintiff filed a suit for permanent injunction, my lord, which came to be decreed, my lord, dismissed. Being agreed by that, my lord, the respondent plaintiff filed a first appeal, my lord, before the first appellate court.
Yes.
That also, in that, my lord, he filed an amended application, my lord, that came to be allowed. And by virtue of allowing the
What
appeal,
is this? You have filed.
memo for listing, your lordship, fresh
Which-
matter.
What is that?
Arising out of an order, my lord, MSI is before this court only. Fresh matter.
Take it. Is it just see it also? Just have a look.
It's a fresh matter. Oh, bless. Huh?
Okay, let's run the list, ma'am.
Serial number.
Lords, kindly, my lords.
Just 1 minute. We'll come back. We're just running it.
Serial number 1, Srimati Revati Nagde.
Not,
What is the, Mr. Biliappa, what are your
yes,
instructions?
he is before the court.
What does he say?
Lord, he says that while he was drunk on a particular day, he was taken by his father to the rehab center and admitted there. So now he wishes to.
Now he wishes to?
Be set at liberty is what it says.
MP. Subhash Chandra MP.
ನಿಮ್ಮನ್ನ ಯಾರು ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರು ರಿಹಬಿಲಿಟೇಷನ್
Yes.
Serial number two, serial number two.
Serial number two, Your Lordship. We appear for the petitioners, Your Lordship.
The custody is
Yes,
handed
where
over
are
to
they?
Your Lordship, appearing for the petitioners, Your Lordship.
Yes.
Serial number two, Your Lordship.
the custody of the minor son is handed over to
Yes, Your Lordship.
to the mother of the minor child
Where is the last?
by the state of
We have produced that status. Yes, tell us, then have you seen the status report?
Yes, Your Lordship. We humbly submit to Your
You have
Lordship's.
seen, you have seen the status, come to paragraph 12.
Yes, Your Lordship.
Come
Yes,
to
Your Lordship.
paragraph 12.
Yes, Your Lordship.
So what do you say now?
Your Lordship, we humbly submit, Your Lordship, on the last date itself, the custody was handed over to the mother, Your Lordship. And after the due formalities,
Has
Your
it been
Lordship.
handed over?
Yes, Your Lordship. On the last date itself, on 13th March,
So
Your
what
Lordship.
remains now? What remains now?
And it is everything is
So we'll withdraw
satisfied,
this
Your Lordship.
petition.
Yes, Your Lordship. Yes, Your Lordship. Very humbly, Your Lordship. Yes.
Just say that Lana counsel for the petitioner states that the custody of the child
Had been handed over on 13th
Oh.
March itself, Your Lordship. And
Has
now he's in
been-
the custody of the
has been-
petitioner.
has been handed over to the mother of.
Yes, Your Lordship. Mother
Has
of
been
the
handed over
child.
to the mother. That
Yes,
is
yes,
the
Your Lordship. On
mother
March
of the
13th.
mother, to his mother. To his mother. Full stop. This fact is confirmed by Mr. Beliappa, learned as PP. The council states that the petition be dismissed as withdrawn. It's ordered accordingly.
We are grateful to Your Lordship.
Serial number three. Lakshmi Narayana, serial number three.
Petitioner, son.
What is the age, Mr. Beliappa, of the girl?
now she has turned 18. She is
18 plus, son. 18,
18
18 years, 6 months. I'm furnishing the
She's
What
your-
does she-
marks card.
What does she want now?
but
You
she's
want
before-
to liberate
She intends.
Where is she?
court, sir.
She's
before the court.
No, she's here today. We are no.
Yes,
Where
but
is she
CWC would put her in a We will take her back.
Pardon?
We will take.
You can take her back and let her be tomorrow here.
It is.
You want to be-
There is a,
Tell her, Mr. Baliappa,
Yes, sir.
just tell her that we will be going there from where she has come. Tomorrow she has to come.
Yes,
Decide tomorrow.
yes.
there is a possibility of threat from the mother side. So,
She's in custody, in the lawful custody of under the state. It's the home is being run by the state only. Yeah, that kind of a response.
there is no order. There is no order. So, there is no order. Put her in the sun.
Who has to?
Police.
See, you're not going to all these, don't get into all these things. Let the parents come and try to solve it. Okay.
Just I want to safeguard her interest.
No, it's a child care center authorized by the CWC, so therefore the
As
such threats.
authorized.
Yes,
It's all right. We don't go, let's not go into all.
yes, we will not go into.
Yes. Let the parents be there. We'll
Yes, yes, tomorrow.
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 Yes.
Serial number 4, Sri Rajan.
I appeal for the appellant. I have filed the LR application. First respondent is died.
What do you say?
My lord,
What are you saying?
the first respondent died and the LR application is filed.
What about 5?
I will take paper publication for the fifth respondent.
Just be issued for this, for service on respondent number 5. This is IA, then IA1, respondent number 1. It appears for respondent number 1.
Respondent number 1 is dead.
Hearing.
We will look, we let the council be here, we will see it on the next day, this LR's application.
Please, ma'am.
We'll issue notice to respondent number 5.
Please, ma'am.
Okay.
No, I'll file the application now.
We know that, let the council be here.
Please, ma'am.
Next.
24-6, serial number 5, Sri Surana.
For applying, my lord. Pray for 1 week time, my lord. I will take steps to paper publication for,
You will file an application.
I will file, my lord.
Sir, left.
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 R1 is there. R2 is there.
So you file an application then.
Next date, I will pray for 1 week time.
Of council for the appellant, re-notify. File it.
10-6,
Next.
serial number 6, Srimati Maitreyi Krishna.
The synopsis has been served on them, my lord. Served it, yes.
I've received the synopsis yesterday in the evening.
We'll just pass it.
Please.
Very well.
Next.
7, serial number 7, Sri Vijay.
I appeal for the respondent.
I prefer the appellant in this matter, my lord. Already respondent has served copies of the objections to the main appeal and
Ready, I'll file in the registry.
Just say that objections have been filed. Well, notice been issued. When was it issued?
Yeah,
15/125.
notice.
Signed by the respondent. Okay, let rejoinder be rejoinder. If any be filed with it. Paper which we filed with it.
25-6,
Now tell us. Okay, sole respondent, no?
Sole respondent.
Oh, next.
serial number 8, Sri G.R. Mohan.
What is the Karnataka granted 4 weeks time on which to pay the court fee. And they deposit 50,000 on last week. And pay for 4 more weeks so that I can pay the 1,20,000 the balance.
Let the deficit court fee be filed within 4 weeks. This time.
25-6. Serial number 9, government advocate.
Appear for state, my lord.
Undertake
to file
wakalat for R3 and for R7, my lords.
4 and, my lord, we have served all, my lord, except R4 and R12. My lord, lordships kindly appreciate NS, but my lord has filed contempt. He was appearing previously for R2 and R4 and 12 also. Kindly direct NS but to take accept notice for them. My lord, will take steps also, my lord, simultaneously.
Fresh note. We say fresh notice for 5. The fresh note will be
5-6.
Obliged.
Serial number 10, Shri Shashidhar.
fresh notice in.
Impleading application are specifically directed to remove the office application arising out of Malada. Impleading application they have filed. In the last occasion, they are directed 3 months time is given to comply the office application.
A week time may be granted.
No, I am opposed for any adjournment.
For what? See, when, how much time was taken on the last day?
A week time may be.
No, but you have not done in 3 months.
3 weeks. Ma'am.
That application may be dismissed. I am ready to argue on merits of the case.
What is the objection about? What is the application about?
The application to implead themselves as a respondents in this case, in this appeal.
Impleading applicant was the member of the said society, my lord.
So how is he relevant for the,
Is not a necessary party.
let's see. So what is your role? Why have you filed impleadment?
My lord, I'm the member of the said society, my lord. The appellant herein has filed for the issuance of mandamus, my lord, wherein sought for the to conduct the elections, my lord. The same said came to be dismissed, my lord. And we are the necessary members of the said, we are necessary member of the said society, my lord. They have filed the appeal before this.
So the society, the party here?
Yes, my lord.
So it's all right. Your interest is taken care of. How are you? Every member should not come now. The society, the party?
Previously, I was the director of the said society.
Maybe today you are not. There must be some director.
Now I'm the member.
Office may be dated to post this. For admission, my lord, there is no office objection.
We will set out. Just say the notice on the appeal. Ma'am, you appear for whom?
I'm here on this, 1 and 2, my lord.
To ensure appears for 1 and 2. Let notice be-
Point number 3, my lord, sir, Prithvi Vadiyar.
3, 4, 5. Returnable on.
25.
Arguing counsel is on his legs before the first court. Can I seek a pass from
Pass.
obliged.
12. Manjunath.
Yes, ma'am. Please say.
Your lordship had referred a ILR judgment in the previous hearing. Madam.
Is the subject matter of challenge.
My lord, it is on jurisdiction, my lord. The application was, in the trial court, the application was rejected under Order 7 Rule 10, upon which they have filed, a writ petition.
Only a petition under 226.
My lord, it is, my lord, I have also submitted the other, citation in the previous hearing, AIR 2009 of Supreme Court.
B, it is a revision petition, which is in substance a petition akin to revisional jurisdiction or a supervisory jurisdiction of this court. Then you have the Rule 4 of the
High Court, sir.
High Court rules. So then it would not be maintainable. It would be a petition which has been decided. If it is filed under 226, then the division bench has the jurisdiction.
But my lord, the commercial,
But tell us one thing,
under,
when an order and IA is filed, you can't file a writ petition surely,
Yes.
challenging that.
no, it is a barred by Section 8 of the Commercial Courts Act.
Huh?
My lord, as per Section 8 of the Commercial Court Act. Notice is available.
But tell us one thing. What we have understood you is this. When an order under Order 7 Rule 10 was, application was passed, it was rejected.
Yes, my lord.
Against their rejection, they could not have come to the commercial appeal. They could not have. The 43 contemplated.
Yes, my lord. Yes.
So they went and whatever you call it. Saying so
Yes, my lord.
because
It
of
is,
the bar under Section 8.
yes, my lord.
That's your case.
Yes, my lord.
So if it was not maintainable,
In the
we are
writ
putting it to you. If that was not maintainable, and also two things, which is something the proceedings were quorum non judice in the sense that there was no authority for the single judge to consider a 227 petition.
Yes.
But can we entertain an appeal against per se 227? This judgment of the High Court will come against us. It says any order, rightly or wrongly, any order. But it is still an order under 227.
Citation, my lords. In that it says, it is the nature of the relief sought for in the controversy.
What we are putting it to you. Tell us one. When an application under 7, you will necessarily, you have to necessarily file under 227. Not you, the other party.
Yes,
They have filed under 227.
yes, my lords.
Your argument is, even 227 was barred because of section 8.
Yes,
Section 8 per se bars any revision petition or any exercise of revisional jurisdiction,
jurisdiction, yes,
be it under 115 or be it under 227.
yes, my
That's
lords.
your case.
Yes.
Putting it to you.
My lord, hence I have filed under clause 15 of Letters Patent Act.
When there is a bar, under the own rules.
My lords.
Under the High Court Act or the rules, there is a bar. There is a bar.
Yes.
Under Rule 4 or Section 4.
Yes,
Can you now invoke letter patent? It's not a case that you are not remediless. You are not a case that you don't have a remedy. You have a remedy, but not before the division bench.
my lord, kindly see,
So we may not.
10 clause 4A. The powers of the High Court in relation to the following matter shall be exercised by division of 2 benches. 4A, an appeal from an original judgment, order, or decree passed by a single judge in exercise of powers under clause 1 of Article 226, 2. And 228 of the Constitution of India.
Files a 220 challenge.
Yes, ma'am.
What in substance the petition is about.
Yes,
So we are now putting it to you. Is a petition under Article 227.
yes.
That 227 is just a revision petition which has been decided, against which 227, the remedy would not be before the division bench in terms of this judgment.
But my lord, by the, if kindly see the nature of the order passed, my lord, the learned single judge has appreciated the facts of the case and has passed an order telling to set aside the trial court decree and the case may be transferred to the appropriate court, my lord.
But tell us one thing, how is the appeal maintainable before division bench?
Well, can I kindly direct
Yes,
this,
tell
in my lords. It is also a similar state where the challenge is to the appeal of the order passed by division bench, which held that holding that the letter patent appeal was not maintainable, which was passed only filed under 227. Well, that's in page number 2, my lords, in para. It says that it is the nature of the relief sought for and the controversy involved which determines the article which is applicable. Later, my lord, in para 3, it says the High Court did not consider the nature of the controversy and the prayer involved in the writ petition. My lords, in this writ petition, my lords, the prayer prayer, my lords, is at page number 33 of the writ. My lord, this is not supervised. This is it is almost sitting in appellate jurisdiction, my lord. They're asking to repeal the order of the trial court and saying that and then, my lord, this
see the 227 when the court is exercising, it may not exercise the appellate jurisdiction. It will still exercise 227 jurisdiction, seeking that largely the order which has been passed is correct or not. That's all. Nothing more. Not an appellate jurisdiction per se. But it is a case where they have invoked 227 also. That's right. To that extent, it is exercising 227 powers, the learned single judge. When it is an exercise of a power under 227, can an appeal before division bench lies? That's the issue.
Yes.
Which, according to the judgment here, it would not lie.
my lord, as per the ILR, my lord, it is that as per the ILRs, my lord, only if the single judge is attracting supervisory jurisdiction, then it will not, my lord. But, my lord, in this matter, because it was right.
The view, it says supervisory jurisdiction. Yeah.
Kindly see the orders passed by the learned secretary 3 and 24 of the
Can we look at? Yes.
para 30, my lord. Having answered the first question in favor of the petitioner herein with regard to second question, para 10 of the plaint mentions about a cause of action as here under. Even on reading the plaint, agreement was entered into between the parties where the money had to be paid by the defendant petitioner, as it has not notice has not been served.
What do you say?
My lord, I have not received a copy of the petition, my lord, but I have a strong objection with regards to the maintainability, my lord.
But how was your 227 maintenance?
Yes, my lord. It has to be challenged before the proper forum and once. Yes, my lord.
226, 226.
My lords, may I please, my lords?
Can't we invoke our jurisdiction?
My lords, may I make?
Yes.
My lord, the power
Yes.
under 226, 227, 32 is a basic structure of the constitution. And even after the amendment of the CPC 115, my lord, still the 227 can be invoked. Here the issue is that once it is 227 is invoked,
Let's put it this way. Does the commercial, you are in a commercial suit?
is inherent jurisdiction of the High Court and it can be invoked at any stage. That's what the 7th bench at the
Please
Constitution
adjust
has
your
held.
camera position. Yes. Now we are only putting it to you. How was
lord,
your
the power-
227, 226, 227 was maintainable?
My lord,
How was it
227,
maintainable?
227 is the inherent power of the High Court. The supervisory jurisdiction.
No, that we know. When there is a bar
The High Court has always got the
under
supervisory
the Commercial
jurisdiction
Courts Act,
against the,
and there is no appeal provided under the
my lord, Commercial Court Act section 8 has been, it has been stated or petition. Petition does not.
The one at the top left or?
Bottom, my lord.
Bottom.
My lords may be posted on 21st or may appear on physically, my lords. 21st may be taken up, my lords.
Let's
Some
have it on
21st may be taken up physically, my lords.
See, we are only putting it to you so that you can just look into it.
Yes, my lords.
We are in a commercial dispute and governed by the Commercial Courts Act.
Yes, my lords.
Commercial Courts Act specifies under 13(1)(a), which are the appealable orders.
Yes, my lords.
Appealable orders under confined to order 43.
My
If
lords.
anything beyond order 43 can you invoke order the article 226 and 227 and circumvent what is not provided under the Commercial Courts Act?
227 is inherent power, my lord. Whether it is 227, 228, 226 are inherent powers. My lord,
Then why did the Commercial Courts Act didn't say that even an appeal would be maintainable under that provision? So we are putting it to you, something which is not provided under the Commercial Courts Act, no appeal, or for that matter, a revision jurisdiction shall be maintainable. And mind it, keep section 8 in view while you consider this issue of the Commercial Courts Act. It bars revision jurisdiction.
My lord, by an
Is akin to revisional jurisdiction.
constitutional powers, my lords.
Okay. So you are saying inherent powers. That's all.
Inherent by an enactment, by a statute, you cannot, or some circumstance, my lord, the constitutional powers. 227 is a constitutional power.
Okay, just look into section 8 of the
My
Commercial
lord,
Courts Act.
maybe on 21st, my lord, I will come and elaborate.
You said
21st of April.
21st.
My lords,
Pardon?
my lord, any date after 21st, my lords, I will come physically and I will assist my lordship on this short time, my lord.
My lord, due to some personal inconvenience, I won't be available next week, my lord. Kindly have first week of April, my lord. I won't be there. I'm available on the 21st, my lords.
Just say that at the request of counsel for the appellant, re-notify. You must look into it. This requires consideration, this issue.
Yes, my lord. In the meantime, let counsel for the appellant will hand over
Just give it
the
in
copy of the
April.
appellant. Grateful,
Sir, 8th of April, sir. Sir, 8th of April.
And just give it.
Grateful.
They should have a copy. Give a copy of the appeal to them.
My lords.
Just give it.
Taken
What
as
is there? We are
notice is
looking-
served to me. Taken as notice is served then, my lord.
So that doesn't make any difference. Just give her a copy, give him a copy. Okay?
Grateful, my lords. Grateful.
Just 1 minute. You have appeared now. You have accepted notice.
Yes, ma'am.
So I'll give a copy. Next.
Number 13. Shri Ranganath Joyce.
Lord, appear for the petitioner, my lord. Lord, appear for the
Yes.
petitioner. This matter relates to
Yes.
payment of provisional pension. My lord, the petitioner was subjected to criminal proceeding and departmental inquiry simultaneously on the same charge of disproportionate income. So
Yes.
far, a departmental inquiry is concerned, the inquiry conducted was held to be defective by this Central Administrative Tribunal, Bangalore bench, and certain witnesses were not examined. Therefore, it was remanded back to the authorities. My lord, after that, in the meanwhile, my lord, the respondents on the basis of criminal case, my lord, in which the petitioner was initially convicted by the court below, and which is now pending in the criminal appeal before the dishonorable court only, my lord, in criminal appeal, where a sentence has been stayed, but the appeal, it is a continuation of the proceedings. In other words, a person, again, when the proceedings are pending, is entitled to the provisional pension. I am not asking for pension, gratuity, or anything which could be subject to result of the ultimate order in the criminal appeal. But my lord, to avoid the payment of this the provisional pension, the department thought of a plan that instead of continuing the departmental inquiry as remanded by the tribunal, they passed an order because you have been convicted in the criminal case, the entire pension is withheld. That order was challenged before the central tribunal. My lord, on
Mr.
the
Joyce, you just tell us one thing.
Yes.
And what is the position of law?
position of law 60, rule 69 says
Position
that
of law, once at least there is already a conviction.
rules on conviction, my lord, the sentence is stayed and it is a proceeding, and rule 69 contemplates, CCS rules contemplate.
The sentence has been stayed. The sentence has been stayed, not the conviction. Let's be clear.
Yes, that is true, my lord. And
When there is a conviction, the consequence would flow.
my lord, under similar circumstances, 3 more officials on the same department, conviction has been ordered.
Let's see what the tribunal says.
Yes. My lord, your lordship will kindly see the order of tribunal, which your lordship will find at page number
Let's see what the tribunal say.
Yes. Annexure, page number 50, starts from page number 10. Page number 170.
Yeah, we don't see anything wrong in this, Mr. Joyce.
Not
The
the-
tribunal is right.
Well, there are two grounds, my lord. One, what your lordship is saying is that
The tribunal is right. You may say that it's a continuation of appeal.
yes, that is one aspect, my lord. That is one aspect.
Okay.
Second ground I have
Yes.
argued is, in the representation made before the authorities, I have said that in identical circumstances, 3 more officials who have been subjected to conviction and whose appeals are pending, for them you are paying provisional pension. Not passed any order, you are paying the provisional pension for 3 of the officers. Only you picked by me and chosen for, because in the tribunal, so far as D is
What are-
concerned, which notwithstanding.
What are their names?
Name I
What
have
are their
pointed.
names?
Kindly, I will
to
point
us?
out. Sir. In my representation, I have pointed it. Kindly, my lord, page number 138 of paper book, my lord.
Page?
Page number 138 of the present paper book, my lord.
Okay. Okay.
This is the representation given before the order of punishment as to why your entire pension should not be withheld. Then one, I argued that it is a continuation of proceedings, therefore it can be done. That is one ground.
That will not hold good.
Yes, my
That will
lord.
not
I
hold
leave
good.
it to your lord. Second is, kindly see page number 138, para 10, my lord. There are
Yes.
good number of precedents on the position mentioned above, and I am quoting certain cases which I can recollect. Sri C.R. Satyanarayana, SRV Satyanarayana P. Srinivas, in respect of above cases, facts of the case were totally similar. These officials were connected and they have preferred the appeal before the relevant High Court. Sentence has been, and they have been granted provisional pension. This is another ground which I had, that you can't discriminate among the appeal, because it was thought of only because I succeeded in the CIT regarding departmental inquiry. This idea was thought of only in respect of me. So as an employer, if you apply the principles, you apply the principles equally. That is the second.
Now, which are the high courts which you are referring to? Which high courts have granted the benefit?
Not high courts, my lord, the department, my lord. In these 3 persons' cases, they have also challenged the conviction before the court, and only sentence has been stayed, as in my case. But in all the 3 officials' case, they have been being given provisional pension. No orders have been passed on the basis of the conviction, as was done in my case. Therefore,
Very well. I don't think so, Mr. Joyce. That's it.
That is the position. I have not answered
Yes,
this,
we
my
are
lord.
not. It's all right. Doesn't make any difference. You can't have a negative equality. This
It
patently
is not
wrong.
negative equality. It is the wrong exercise of discretion, because at the same time you have decided that these persons, for the awaiting the decision of judicial proceedings, because I approached the tribunal challenging the departmental inquiry proceedings and I succeeded, the employer is discriminating on the ground, on the same set of facts. Parity, my lord. That is what they are. The only it borders on malefides, my lord, because in the same set of circumstances, it is true that it is the discretion of the employer to continue or not to continue or to pay the provisional pension. But you can apply the principles to 3 persons, but only take 1 person for discrimination. That cannot be allowed, because as an employer, you cannot discriminate on the same set of facts. That too in a particular case where I succeed in the departmental inquiry, get an order that the inquiry should be held. They abandon it straight away, and suddenly they pass an order on the basis of the criminal case, which was pending long back. 2016 is the date when the case was pending.
That's all. Anything else?
That is all, my lord. And this person is senior citizen, my lord.
All right.
His health is in a very bad, and at least the criminal appeal also is not being disposed
There are
of.
proceedings pending.
May I make one
Pardon?
request, my lord? If your lordship is not convinced on these aspects, my lord.
Yes.
I will only request that the connected petitioner may be permitted to move the criminal appeal, which can be disposed before, which is pending before this honorable court only, so that expeditious disposal of the appeal will help him. That is all what I can make.
We say nothing There is no bar for you to seek an early hearing.
That we have
You
done
would listen
several
to the
times.
court, Mr. Joyce, you to go to the concerned court and seek an early hearing of your appeal. Okay, but this
I will do, my lord. That I will do,
this
but they are
prayer
not granted.
in law would not be maintainable. And to my recollection, there is a judgment of Delhi High Court on this.
No, no, that I am aware, my lord, that the conviction is enough to
Okay.
impose the punishment. But only thing is, among them, my
Just
lord,
say this, the
in same
challenge in-
fire, for 3 persons you apply one principle, for another you apply another. In that, it is not
but that we believe. That we
that
believe.
it is not negative
Just say this.
that I am seeking. Improper exercise of power, picking and choosing people for exercising the discretion which you have there. That is all what.
Yeah, okay. This 176. The challenge in this petition is to an order dated 24th October 2018, passed in 982 oblique 216. The OA filed by the petitioner herein by stating in paragraphs 1 and 2 as under. The only plea urged by Mr. Ranganatha as Joyce, done a counsel for the appellant. The two pleas are that though the criminal proceedings have been initiated against the petitioner for disproportionate assets, and the same has been and the same wherein the petitioner has been convicted, against which is in the nature of a continuous proceedings, and as such the provisional pension which was being granted, which was being paid to the petitioner while the criminal proceedings were in progress, has been withdrawn, which is illegal. To stop his other employees are being given provisional pension. Those employees who have been given the benefit of provisional pension, even if there is a conviction against them and they have filed an appeal. So we are not convinced with the submissions, both the submission made by Mr. Joyce, for the simple reason that the conviction having been effected. Are you governed by the CCA rules?
CCA rules and CCS pension rules.
Okay. Having been convicted, the CCA rules through vide rule 19 provides the competent authority to take action against the employee against whom a conviction has been against an employee who has been convicted in a criminal proceedings. Full stop. It is not denied the fact that after the conviction, after the petitioner was convicted, action has been taken against him, and for that reason, the provisional pension has been stopped. Full stop. If that be so, though an appeal has been filed wherein the sentence has been stayed, the conviction still continues to hold good till such time the appeal is decided. So insofar as the second submission of Mr. Joyce, that similarly placed employees have been given the benefit of provisional pension, the finding of the tribunal is in paragraph 2, which we have already reproduced above. Full stop. Assuming that certain persons who are similarly placed, like the petitioner, have been given the benefit of provisional pension, such a benefit cannot be given to the appellant, or given to the petitioner herein, as upon conviction by the criminal court, the final order has been passed by the respondents, which entails denial of any pensionary benefits upon conviction. Full stop. And accordingly, we do not find any merit in the petition. The same is dismissed. Next.
Observation
that
to the
you can
effect
do.
that
There is no, you don't.
if your lordship make it, it will help to some extent because the matter is not being taken up. It's just an observation that
You
it is
don't-
open for the.
No, Mr. Joyce, it's not. You have to go to the concerned criminal court and seek the early hearing. It depends upon what is the board
High Court, it is
position
before
there.
High Court.
It's all right. No such observation. Next.
Serial number 14, Shri Rajesh.
Here for the appellant, my lords. The
My
respondent
lord,
has,
my lord, I
respondent
prefer
is,
I prefer the respondents. The matter is already disposed of and wherein there is subsequently an arbitration award. The parties are landlord and tenants, and the respondent, I represent the landlord. During the pendency of this proceeding, a certain amount was deposited by the tenant before this tribunal, before this court. Later, the court appointed the arbitrator. Arbitrator has completed his award on 30/11/2024, and in his award, at operative portion 15, X B, he refers to this deposit and says it may be given to the respondent who is the claimant therein. That I am seeking for refund, withdrawal. Permission.
Who wants to withdraw?
I have to be permitted to withdraw. It has to be
the appeal.
not the appeal means the amount in deposit.
The amount in deposit.
Okay, you have filed this. Oh, you have filed only for that?
Yes, madam. It's a disposed of matter where by virtue of arbitral award we are paying it.
When was the amount deposited?
My lord, it has been referred by the court. It is deposited in this court. Para 24 and 25 may keenly be seen in the award report. Page 11. The tribunal also refers to it.
When was the amount deposited in the court?
My lord, in 2021, pursuant to the order dated 12/3/21 of this honorable court.
12/3/21?
Yes, my lord. It was deposited on 16/4/21. Lordship may kindly see the order sheet of 12/3 and followed by 16/4.
So 50 lakhs has been deposited.
Yes, my lord.
Now what is, has the tribunal passed the award?
Yes, my
Yes,
lord.
my lords. Now there is a direction by the honorable tribunal to adjust this money which we have paid towards the money payable to them. And there is also a further direction that if I am entitled to some money as per the award, that also is to be adjusted. Therefore, my request to my lords is let both of us file a memo of calculation as to how much we are entitled to receive and how much they are entitled to receive.
What happened in the arbitration?
Because arbitration matters are closed. Our claims, his claim is allowed in part. My counterclaim is allowed in part. There are mutual payments to be made.
So there are mutual payments to be made.
Please, my
I
lords.
think then you better file a calculation under the award. What is
But
payable?
may I submit? Insofar as
Does
this
the-
portion of the amount is concerned. May I submit?
As the arbitrator says, what is the whatever is payable under the award, you will take it from the after seeking the release of the amount?
Yes, my
My
lords.
lord, may I read the portion which is relevant for this, my lord? Para 15 of the award. The amount deposited by the respondent.
Along with the application, my lords, they have filed the operative portion, my lords. IA 1 of 25.
The amount deposited by the respondent before the Honorable High Court of Karnataka in MFA number 508520.
Just 1 minute, please. You said 125?
105, my lords, page number 105 of the award.
Yes. Read it.
XB 15, the amount deposited by the respondent before the Honorable High Court of Karnataka in MFA number 5085 of 2020 and the interest accrued thereon be adjusted towards the arrears of rent payable by the respondent to the claimants.
And the next
And
clause.
the claimant there, Mr. Rajeshwar is the respondent in the arbitration.
The claimants, while claiming the amounts due to them as per this award, shall give deduction to the amounts payable by them to the respondent as per this award. So there are mutual payments to be made, my lords. And deductions and adjustments have to take place. Therefore, I requested, my lords, my learned friend also file a memo of calculation. I will also file a memo of calculation. If I have to give, then this I will agree for return of the money, my lords.
You will file your calculations, respective calculations.
My lord, Lordship may kindly see the entire portion. Insofar as this direction, it is only for the purpose of refund, withdrawal and given it to me. I have to file an execution or he has to file an execution where it has to be adjusted. Because there
Very
are,
well.
the rents are, the tenant is continuing to be a tenant. By virtue of this award, tenancy is not, the tenant is not allowed to be evicted. He continues to be a tenant. Every month he has to pay 6,66,000 to me. Lordship may kindly see the other portion of the, there are also arrears to be paid by him which he has not paid. So all that is to be adjusted, not just this amount. The entire, Lordship may kindly see the operative portion running from page 102.
How would we know under the award you are entitled to 50 lakhs?
Lord, the entire calculation which may be done, which may be seen. Every
Pardon?
month, as he is continuing, he has to pay 6,66,000.
So there must be something on record for us to determine that.
Lord, there are two. I have challenged this award in the Mysore court. He has not challenged this award, nor has he taken stay in this against this award. The total award says you pay him what he has to pay to the landlord. It has to be adjusted. He continues to be a tenant. 6,66,000.
You're right. You're not understanding. Even continues to be a tenant, even as on date, he is entitled to 50. You are entitled to 50 lakhs post award period also. But there must be some calculation.
Lord, that we already filed it in the section 34 code. That is a subject matter of the court.
No, that's a different argument. He may not have approached 34 code. You have approached 34 code.
Yes.
But you are claiming this refund on the basis of the award.
Yes.
So we want to know on the basis of the award, what is your entitlement?
But that has been determined by the court, I'm saying. The
Very well.
arbitration.
If you are saying so, let the determination be happen by the executing court, and
Yes.
then thereafter you seek the release. See, it's either one of them. You may be right. Then you go to the executing court, gets the amount determined, and come and seek an file an application for the release. We will release.
Lordship may kindly go back to the operative portion of the award, para 153, which I read, my lord. Then the court, I would abide by the court order.
Yes.
The para 3, my lord. 153.3. The respondent, that is Mr. Rajeshwar's client, shall pay a sum of rupees 84 lakhs towards arrears of rent till 18/6/2020, the date on which the suit was filed, with interest at 12% per annum from 18/6/2020. So as it is, as against this 50 lakhs, 84 lakhs is due by him.
Kindly come to page 103, my lords.
1 minute. Page operative portion 4. The respondent shall pay arrears of monthly rent at the rate of 6,66,000, etc. per month from 18/6/2020, treated as claim petition in so and so with interest. So that also is liable to pay. He is liable to pay in huge amount, almost to the extent of 10 crores.
Just 1 minute. Is it your case?
My lords.
Your liability is less than 50 lakhs
Not
under the award?
No, my lords.
Then what?
His liability is also more than 50 lakhs under the award. Their liability.
Why you?
Please, my lords. Kindly see the page 103, Roman 9, my lords, small Roman 9.
Yes.
A sum of rupees 76,66,678 received by the claimants from the respondent is treated as refundable security deposit repayable to the respondent with interest at 12% per annum thereon. Then, my lords, Roman 12. Respondent is entitled to recover rupees 42 lakhs for 2 terms from the claimants. The said amount of rupees 42 lakhs recoverable from the claimants with interest at 12% from 4/3/2023. The date on which the counterclaim was filed by the respondent till realization. Apart from this, respondent is entitled to recover a sum of 12,82,600 with interest at 12%. So therefore, my lords, I suggested that let both of us file a memo of calculation so that if I am liable to pay, then I will concede for withdrawal of the amount, my lords.
And on the face of it, it is liable to pay.
Just say
Because
this.
every month it is accruing. My liability is increasing. That is why his liability is increasing. Whereas his liability, which he has to pay, has stopped. So even then, by going by mere mathematical calculation, what he has paid, as he admitted, is 50 lakhs, is less than what he is to get. So 72 lakhs, he says. And 4 months have happened after that. November 30th is award. December, January, February, March has happened now. He's also due to pay on 1/4. So keeping that in mind, huge amount is due to me as compared to what amount is liable to pay, liable to get. And that is again a subject matter of the challenge.
See, before we also pass an order for release, we should be convinced under the award, this 50 lakhs is actually payable to you after adjustment, after all adjustments.
Yes, my lord, that's what I'm saying.
We don't want a situation where at a later date, it is found you were not entitled to 50 lakhs, you were entitled to short of 50 lakhs.
My lord, may I say?
So that's the reason better what being said, file your this thing, or you want to work it out before your executing court, work it out. We will adjourn this application sine die till such time the executing court works out the liabilities. Then you come back.
My lord, may I make one 6 lakhs, 66,000 into 6 months or 7 months is 50 lakhs. He is already there from last 4 months without paying.
Plus, every month I have been paying the current rent, my lord, 6
No,
lakhs.
it is not the current rent.
Now tell us what you want. You want to file the calculations?
I'll file my
If you file exchange so that we are at we can understand what is the liability qua whom.
Obliged.
Just say that this is an application filed by the appellant with the following prayer. Respondent with the following prayer. It is agreed by the counsel for the parties that they shall file their respective calculations. Calculations in regard to their entitlement under the arbitral award dated
30th November 2024.
30th of November 2024. Let the same be filed within 3 weeks. List on.
Great.
The same be filed and the council, it is made clear the council shall exchange their respective calculations. Calculations. Next.
5-6. Serial number 15.
Lord, may I request for it to be before vacation around 5-6, I think is the hearing date.
24-4.
Okay.
15.
Appear for the petitioner, my lord.
Yes,
Hello.
where are we now? Yes, ma'am. What are your instructions?
Well, now my instructions are, he has served with us only for 9 years, 4 days, So my contention is he does not have complete 10 years of qualifying service. Now his last time submission was that he resigned from IB and he went to DRDO with 2 years lien from us. And then he came back for a day, which is not true. He has not come back for a day because he resigned on that day. And same day he asked from us for relieving. That is in 1984.
Where did you go from IB?
To DRDO, my lords, defense.
DRDO.
So he resigned.
How much he worked for? How much time he worked for there?
They're not even 2 years, my lords.
No, in DRDO.
About 1 year and 9 months.
1 year and 9 months.
9 months. So then, my lord, I came back to.
Same
IB.
day you resigned and went back.
That after reporting IB, my lord, the same day I resigned and reported to.
Who would discharge the pensionary liability for 1 lakh, 1 year and 9 months?
My lord, as per the Government of India rules, my lord, it is there is no dispute on that. My
Dispute
lord.
means what is your stand on that? Who would discharge? Why should IB discharge? IB will not discharge. You work in a different organization.
My lord, it is under the Government of India only.
Doesn't make any difference.
My lord,
Still, for the purpose of, that's our understanding, for the purpose of payment of pensionary benefits, it would be the obligation of that department. Under an umbrella Government of India. But it is still a third entity, DRDO.
My lord, the OM, my lord, states that, my lord.
Read it.
No allocation of pensionary liability between the departments of central government. The rules in regard to allocation or sharing of the liability on account of pensionary charges of government servants with service under more than one department among the departments of the Government of India, including railways, posts and telegraphs, and the defense departments contained in appendix so and so to account code volume so have been under review of the Government of India for some time. After consideration of the various issues and keeping in view of the need for simplifying interdepartmental adjustments, it has been decided to dispense with the system of allocation of pension. The liability for pension, including gratuity, will be borne in full by the department to which the government servant permanently belongs at the time of retirement. No recovery of proportionate pension need be made from the central department under whom he had served.
And where is that, after he came back to IB, where is that resignation?
It's I'll place on record.
So effectively, you know, what is he seeking now? He's seeking that 10 years entitlement, whatever is pro rata,
Please, madam.
that should be given to him. Just 1 minute.
Please.
When he worked in IB, he went to DRDO. Cumulatively, both the periods,
Please, madam.
when he was holding lien in IB, it's more than 10 years. It's not less than 10 years.
No, in IB only 9 years, 4 days.
Don't say in IB. He has gone
In
to
DRDO
DRDO through
Yes.
proper channel,
Yes, my lords.
went to DRDO, holding a lien here,
Please.
and came back.
No, that is what I'm disputing now.
Why?
He has
Just-
not come
just
back.
first minute.
Please, my
Why
lords.
do you,
I will take my lords to the first document in that. my
why
lords.
do you say he didn't come back?
Please, my lords.
Or did
Why-
he resign from DRDO
He resigned from DRDO.
and then went
I
out?
will just take my lords to the second document in that, my lords. That is given by me, my lords.
But
Sorry,
the
that
writing-
is given by him. Kindly see, as I have been selected to the post of Deputy Vigilance Officer in Indian Telephone Industries Limited, Bangalore, for which I had applied through proper channel, I hereby resign to the post of ACIO, which I am holding on lien. That is with me. My resignation may kindly be accepted with effect from 30/1/1984. My lords, this date becomes important. The next document, my lords, is the DRDO where he resigns. The resignation tendered by you for taking up the appointment of Deputy Vigilance Officer Grade 2 in Indian Telephone Industries Limited, Bangalore, having been accepted, you are relieved of your duties in this establishment and with effect from 30 Jan 84. So here also he is relieved of 30 Jan. With me also he is relieved of on 30 Jan. So he couldn't have come back is my contention, my lords.
Why did you resign from DRDO?
I reported back to IB.
No,
and-
what is this letter? Page 13. The one she has read. You have seen that? This is, you should not have resigned from DRDO. You should have technically come to IB,
My lord, I have come back to IB, my lord.
but how, why this resignation to DRDO?
My lord, if the copies are given, my lord, I'll answer it tomorrow. I'll just put it to my client. My
But no,
instructions are,
You will see the contents. We don't want to see the contents and put it to your client.
my lord, your lordship may kindly see, my lord, their reply in the first round. Your lordship may kindly turn to page 91, annexure A14.
Yes.
My lord, relevant portion is at page 93.
Hmm.
My lord, 4 lines down, my lord, from the top.
Hmm.
As ITA Limited is an autonomous organization under Government of India, Shri Mohan Lal can be given pro rata pension benefits on the basis of service rendered in the IB together with the LRD, so and so. And this amount can be granted to him only on the basis of the option exercised by him as per the provisions of the relevant rules. Yes, my lord, may not be relevant. Para 7, my lord, they reiterate once again that it could be given.
Where are you, on selection of ITA, Mohanlal submitted resignation, was relieved from DRDO. On the basis of resignation letter, this, his lien with IB was terminated on 31. The LRDA was requested by us to remit his leave salary pension contribution for the period. That's what we are saying. Pension contribution has to come from DRDO. Our LRD authority, while the letter did reply that as Mohan was retaining lien with IB, there is no provision. Accordingly, the pension contribution for the period or was sent to the ESI corporation by us through a bank draft. However, ESI Bangalore letter requested to send a lump sum pro rata.
Sent to ESI.
Was it a pensionable service?
My lord, it was a pensionable service, but there was a break, my lord.
There was a break.
There was a break. So because of that, my lord, they sought it back from ESI.
Who has sought it back?
My lord, IB.
And I think, ma'am, you should. See, this is your commitment also. If
No,
you
my
see
lord.
this, you see these lines,
Para 7 minutes.
I will tell you. On his selection to ITI Limited, Bangalore, Mohanlal submitted his resignation relieved from DRDO on 31/2024, 84. On the basis of his resignation letter of 31/12/83, his lien with IB was terminated on 31/1984. The LRD DRDO was requested by us to remit his leave salary and pension contribution for this period. Our LRD. Why did you ask for the pension contribution?
My lords, I'm not aware of it. I have to seek instructions as regards.
I
the
think, ma'am,
expense.
this is sufficient, ma'am. Why are you asked for this? This is only to pay because ultimately he got relief from IB. You will say this is your complete amount for DRDO and for us. That's all.
My lords, one more submission. As regards this, I need some time, my lords. But otherwise,
Ma'am,
I was told, but there was some confusion they had. Earlier they thought that they were liable to pay pension, but my lords, they only chanced upon one OM, which is produced at my lord in my objection statement, Annexure R3. Page 11, I have produced.
There's one thing.
Where, my lords?
Forget all this. He has put in 10 years of service under the government of India. Cumulatively under IB and DRDO. For 10 years, whatever is the effect need to be given.
My lords, but he is not claiming in DRDO. He's only claiming against me.
That's what we will record. And mind it, we will going to record your submission. You are only confining yourself, the pensionary, the terminal benefits or a pensionary benefits to the extent of your service in IB and DRDO.
Please, my lord, that's all.
He's saying so, that we had no. So we'll only confine to that.
May I please submit one more thing? Now, what he resigned from DRDO, he had 2 years lien with me. He resigned DRDO before that lien got completely utilized. As in, my lords, there was still 1 month of lien left.
But it doesn't.
Can he partially take benefit of that lien is my lords.
No, but he said, you don't say so. You see, we just with the one which we have read now. 90.
93.
95. You see 95. No, 92. You see 92. On his selection ITA, Bangalore, Mohanlal submitted resignation from DRDO. See the date, 31/84.
Please, my lords.
On the basis of his resignation letter of 31/12/83, his lien with IB was also terminated on 31/84. The LRDO, DRDO was requested by us. Now you are requesting to remit his leave salary and pension contribution for the period 1 to 82 when he went to DRDO to 31/84. However, LRD authorities, while they reply, Mohanlal is retaining lien with IB, there is no provision to remit the leave salary pro rata pension contribution. Accordingly, pension contribution for the period of this amounting to due was sent to ESI Corporation. Who has sent this to ESI? You must have sent it. IB must have sent it.
IB sent it, my lord.
My lord,
have sent
there
it
was
to
some
ESI.
confusion with the officials. That's why they said this. But otherwise, they want to retract from this statement because ultimately, my lords, there is no estoppel against law. Now, Rule 26 apply because he has resigned all through. There is forfeiture of his service and also, my lords, the lien cannot be counted.
Technical resignation. That's a technical resignation.
My lords, I concede, my lords, but my issue is only this. Now, he has not completely utilized the lien period of 2 years. Before 2 years got exhausted, 1 month prior to that, he resigned from DRDO. How can he select only 1 year, 11
Why
months?
do you say before that he resigned from DRDO? He resigned on 31/1984.
3194, 2 years is not completed because with me, he resigned 1 year, 11 months back. My lord, so my
Alright.
lord, see my resignation date.
He is also 31/84.
Well, he resigned from me, technical resignation on 1/3/82. And then from there onwards, he held a lien for 2 years. So it should actually be 31/2/84. Is his 2 years will get completed.
No, but DRDO is giving that pension contribution to you for that period. 31/82. Did the DRDO gave the pensionary contribution?
My lord, that they only, my lord, will be in a position to
No,
tell
they have
that.
not yet remitted to us or anything, my lords, but otherwise also now he has last occasion he has filed for impleading of DRDO. So they should also come before this honorable court and say, give a statement.
What does the tribunal say?
Tribunal says, my lord, I have resigned 37, so nothing is.
How would you answer that?
My lord, I rely on rule 37 only, my lord.
But here the 37 has no applicability. 37 is on absorption.
Absorption, my lord, what 37 says is, the day on which I report is the date of absorption.
Now, where are you reporting?
My lord, I am
In this-
reporting
After you resigned from DRDO and IB, where are you reporting?
ITI, my lord.
ITI is not a pensionable service.
Yes, my lord.
So then it doesn't make any difference that, and it's not a case of absorption in ITI. Even assuming for a moment, it's a appointment in ITI, but it's not a pensionable service there.
So, my lord, what I might submit is, till then, my lord, I am entitled to the pension, my lord, from the previous employer, that is Government of India.
For that, they say you have resigned.
My lord, resignation, my lord, does not forfeit. It protects me.
How?
Rule 37, my lord, protects. Rule 26,
No.
read with.
You see, 37 is a different eventuality. Means you are here, you go to a public sector, you get absorbed there. You get absorbed there.
My lord, 26(2). Shall not entitle forfeiture of past service if it has been submitted to, and 37 says, if I take it, my lord, to a non-pensionable establishment, my lord, a government servant who corporation, company, or a state government, or in or under a body financed by the central government, shall be, in case of a government employee joins a corporation or a company or a body on immediate absorption basis, the body. My lord, this has been interpreted, my lord, in the recent decision of the Honorable Apex Court. If your lordship permits, my lord, I place it before your lordship.
May I please take my lords too?
Just one minute, let's see this.
Huh.
My lord, the first decision, my lord, State of Rajasthan versus O.P. Gupta.
Okay. So from IB, after you took resignation, you went to ITI.
Please, my lord.
You joined the same day?
Yes, my lord. Same day I joined.
Yes, ma'am.
My lords, may I please take my lords to 202 page number of the petition, my lords?
It's all right.
That's just,
It's a
I'll
matter
just
of
read,
10 months.
just
10
4
years.
lines, my lords.
Which number?
Page number 202 of the petition, my lords. Para 19. As discussed in the preceding paragraphs, no material is placed on record to establish that the applicant was absorbed in ITI or any corporation or company or autonomous body to attract Rule 37 of the pension.
And we are also clear on this. 37 has no applicability.
Yes, my lords.
It's not a case where he has gone on deputation, then got absorbed. It's a case of a fresh appointment. But what is being said here, even in the Supreme Court, when I am applying through proper channel to go to a third organization, when I get an appointment there, I have to technically resign.
Yes, my lords.
Although it should not be technically resigned in that case. But the fact remains that it was through proper channel, you allowed me to resign so that I can join there. He can't be allowed to retire because he
Yes.
doesn't have that 20 years of service to retire.
Hmm.
You getting the point?
Yes, my lords.
It has to be technical resignation. And that appointment to ITI was through proper channel. So he is only seeking that protection of that 10 years of service he can get pro rata. That's all. And that's the intent of this judgment also, if you see, of the Supreme Court. Paragraph 22. There can be no doubt that resignation from service may entail forfeiture of past service. However, sub 2 rules craves out an exception. The said rule clarifies that a resignation with proper permission to take up another appointment, whether temporary or permanent under the government, shall not entail forfeiture of past service.
My lords. Now, my only submission is, my lords, if that lien period is added to my service, that is 9 years, definitely he will have a qualifying service. But he resigned from DRDO before the lien period got exhausted. So how can he take benefit of the lien period is my, lords.
Let's assume for a moment he had completed 2 years.
Please,
and
my lord.
then he would have gone to the ITI. He would have still resigned.
Yes, my lords.
He would have still resigned. Technical resignation would be there. Would be technical resignation. You can possibly although he is relying upon Rule 37, Rule 37 has no applicability. Rule 37 only contemplates you are working in government. You go to a new organization, which is also pensionable, and you get absorbed there. Then you will seek a technical resignation and you get absorbed in the new organization. Then there would be a continuity. But that would be still a technical resignation because you have to sever your relationship with your previous employer. So that it is basically for that. And you continue in the new organization. In this case, it is not pensionable in IT in that sense.
Yes, my lords.
It's a case of a fresh appointment. What he says is, I have applied through proper channel. You have allowed me to apply for ITI. Now I got an appointment. In the meantime, I went to DRDO, came back. I worked in DRDO for 1 year or so much. And if that period is counted, it is more than 10 years. And as such, I am entitled to benefits for 10 years. Interestingly, DRDO, in terms of this page 92, which you are referring to, DRDO has discharged its liability for that period when he was in DRDO. 92. See, on a civil assistant LRD ministry, he was relieved from IB. The LRDA was requested by us to remit his leave salary and pension contribution for the period 1382 to 3184. However, replied Mohanlal, retaining lien IB, there is no provision to remit leave salary and pension contribution for this. Why their letter reply that as Mohanlal was retaining lien, there is no provision to remit leave salary pro rata contribution. Accordingly, the pension contribution for the period of his service in IB from 26/2/73 to 31/84 was sent to ESI Corporation by us through a bank draft. Mind it, you have sent complete contribution till 31/84 to ESI Corporation, till the date when he was there. Even though that period he was in IB, DRDO also, even for no, this is, we are seeing your reply. We are seeing this is your reply. And just tell us one thing. Have they sent the pension contribution for the period of DRDO also to ESI?
My lord, everything was sent for the entire period.
Till 31/84.
That was, then my lord sought back, they returned it. Because there was.
They returned it.
They returned it.
So that means you got it back from ESI. So that must be lying with you.
Yes, ma'am.
And this is what he's claiming from 73 to 84, give me. That's what he's claiming. Take instruction, we can have it tomorrow, take instructions on this.
Please, ma'am. Can
See,
it be
this
taken up on
line is important, what they're saying. 73 to 84, we sent it to ESI. Now he is saying ESI sent it back. That means that's lying with you. That's what he is claiming now. You ask them what happened to this 73 to 84 contribution.
Yes.
Where is it lying after you got it from ESI? Where is it lying? Must be with you. And he is asking for that. Then you must give it.
Minutes, can it be taken up on Monday, minutes?
Okay. Just say that at the request of counsel. We have heard the counsel for the parties at length. At the request of counsel for the respondent, re-notified. Next time is the last hearing, ma'am.
Please, ma'am.
We have given a lot of time on this.
Yes, ma'am.
Next.
Before three. Number 16. 16.
Madam, just take this.
My lord, may I retain this and take instructions from one copy?
No, just give it back to her. Let them have a look. You have seen it, na? The contents, you have seen it.
My lord, I may.
Now, see, now it's only in the narrow compass. So only let her take instructions. Just take it. Next.
16.
And just keep it in the.
Section 37 appeal, my lords. The award has been upheld.
Pass over.
Seventeen.
Plaintiff's appeal, my lord.
Yes. Did we hear this?
No, madam, this is the matter, the CIRP process was pending and we had deposited the court fee also. There's a case, my lord, where we supply tor steel to the defendant. According to us, my lord, the defendant owes us a sum of 4 crores and we filed a suit for recovery of 4 crores. According to the defendant, we have paid, we have received a sum of 53 lakhs for which we have not delivered the goods. And they filed a suit, my lord, for recovery of the 53 lakhs. Our suit was dismissed. Their suit was allowed. My lord, the crux of the case of the plaintiff, that is the appellant before my lord, is that it is even the case, my lord, if my lords please see reasons, the judgment starts at ink page 32. The reasons are ink page 44. That is paragraph 13. The admitted facts are that the defendant, that is the appellant before my lord.
But how would you come over this delay, Mr.
Yes, my lord. My lord, we had filed the first appeal in 2021. The judgment was passed on 33/21. Thereafter, 24/21, my lord, there was a moratorium period because of the defendant being admitted to.
Defendant was admitted to
Yes,
moratorium.
Yes. They were admitted to moratorium, then on 5
issue notice.
My lord, we are seeking, my lord, for a, because what has happened.
You will serve them.
Yes,
You have a judgment, rather judgment against you.
yes, my lord. My lord, we have remitted 40 lakhs in the execution proceeding. And the executing court has also attached our account to the extent of 56 lakhs. The,
Serve
what we're
them.
submitting, my lord, is
Serve
that
them. All right, serve them.
in the short date, my lord.
Respondent number 1 in this one.
It's very. Yes, this is the same early hearing.
It's
No.
the same earlier hearing.
Oh, what do you say?
Regarding that highways,
I have no objection to that.
We'll allow it, we'll fix a date.
Please, Your Lordship.
Okay, next week.
I apologize. On
any-
that day, my colleague had some confusion, Your Lordship. I had in fact informed him that I had a matter before the Supreme Court, and I've told her that to be taken on 19. She waited in the morning and she couldn't reach to the court. There was an urgent matter. She went there. Then she communicated to another colleague of mine. Since there was a confusion, you mentioned it as 19th and it went to 19th.
Just say that this is an application seeking early hearing of the appeal by respondent number 1.
1.
The learner counsel for the appellant has no objection. If the application is allowed, accordingly, the application is allowed and disposed of. List this appeal for hearing on next week. Just give it next week.
Your Lordship, one request, Your Lordship. May the trial court records be called for, Your Lordship. Herein, their contention is that right to fair compensation is applicable herein. But my deposit is in the 2014 itself, Your Lordship. That has to be tested and that has to be looked into. For that reason, the trial court records have to be examined, Your Lordship.
No, the trial court record will not come by next week.
One submission may I make, Lords. The only question which they are raising is regarding the applicability of the new Act, which is a legal question that is involved. What's the parameters that has to be looked into is only regarding the compensation being paid to the majority of landowners.
You don't mind hearing it. If we require any document, then we may have to.
We
defer
have all
it.
the records. In case required, we can assist the court by
No,
filing.
but have you filed it?
I have filed it along with the memo.
Complete record?
Yes.
The same record, but the reason being is that the course, how it has taken place has to be also taken into consideration.
What?
Reason is, Your Lordship, preliminarily, we had issued a notification for the acquisition of the land. And upon that, we have deposited the amount before the competent authority. There, they have not made any application before the competent authority. Directly, they go and knock the doors of the arbitrator. And then the arbitrator has enhanced it from 3,000 rupees to 7,000 rupees. And it is an extremely high amount which has been intended without applicability of it. And then it has come to the district court. It has been saying that right to fair compensation is applicable. If that to be taken into consideration, the course has to be taken into consideration. That can be only demonstrated to their records, Your Lordship.
Do we have the land acquisition officer award?
We have the land acquisition officer award. Your
Translated copy?
It's in English, Your
It's in
Lordship.
English.
It's in English.
It's in English. That is furnished.
Let's see that. If you
Yeah,
require
please,
record,
please,
we'll
Your
call for it. What
Please,
is that?
please.
One submission may I make, Lords. Lordships have posted now, Lords, for hearing. Now the stage was for admission. In fact, it's not heard on admission still, Lords.
What difference it would make? These are all nomenclatures.
Very, very.
And mind it, we are not in that sense regular first appeal.
I
Let's be clear. We are in 37.
That's why, Lords. If it can be posted for admission and if it can be on an understanding for a disposal heard,
That
Lord,
make any difference?
I stand a better chance of reaching the matter. Sorry.
Pardon?
I stand a better chance of reaching the matter.
Doesn't make any
In the
difference. No, reaching, you will reach. Okay, just say give the date next week, man.
26/3.
What is this IA number?
2 of 25.
2 of 25, na? Where is that, man? 2 of 20.
2 of 25. Sorry.
Now, who are the respondents here? Just 1 minute.
appeal.
Respondents are one, the.
Lord, so far as second respondent is
Only
the
one.
arbitrator.
Only one.
I am the only one who is
Oh.
contesting.
Just say notice to respondent number 2 is dispensed with being the
Arbitrator.
arbitrator. By the state appears.
State appears.
Government advocate appears. It's all right. Don't say so.
Please, Your Lordship.
Okay, next.
I'm obliged.
Much obliged.
Number 19. Prakash B.
But the decree holders appeal, Mulad.
Yes.
But I had the decree passed by the.
Make one submission. I want to produce a synopsis with certain documents. These documents have been referred to by the executing court during the course of its order. But those documents which are notices are not before this honorable court. It is ready, please, my lord, if your lordship may accept it in the court. On my others, I'll file it before the registry.
Execution is dismissed on the ground. It is because of the efflux of time.
Efflux of time.
Lord, I had the decree for restoration of possession, and it has become final. I was the tenant, Lord. I have taken the premises for running the restaurant. I paid 32 lakhs as security deposit. At one fine day, I have been prevented from using the premises. Therefore, within 6 months, under section 6 of the Specific Relief Act, I have filed a suit for restoration of possession. Suit came to be decreed. And then, Lord, I filed execution for restoration of possession. An objection was taken by the decree holder, saying that it is not maintainable. That objection was overruled by the executing court. Then a third party, who is none other than daughter of the landlord, has filed an application under section 47, saying that execution is not maintainable and therefore dismissed the petition as a third party objector. That application came to be allowed. Court says by efflux of time, the execution is dismissed.
What was her locus?
Her locus was she got the gift deed after the decree was passed.
Yes. So what do you say? Now we can hear it.
Yes.
Lord, I need to make that, produce those documents with a short synopsis. Because those documents are referred to by the executing court during the course of its order. But those documents are not available before this honorable court.
In fact, my lord, in the premises, I had the materials worth 2 crores and my 32 lakhs deposit also not returned. I have been thrown out of the premises and quite a.
No, but that's a different argument. One is possession, the other one is whatever entitlement to the benefits.
Okay, because decree says that they should not remove those materials from the
Not
premises.
they. He should not remove.
What was the purpose to say so?
Well, because my materials were inside the premises. Of course, in decree, by mistake says plaintiff, but it should have been defendant. Because if we read the entire judgment, our material was there, they have locked it. So therefore, court said they should not remove it.
Just say the request of counsel for the respondent to file synopsis and certain documents. Re-notify on. Liberty will be counsel for the appellant also to file synopsis.
But that note may be.
Now it's only respondent number 2 now.
Please, respondent number 1 is no more.
No more. Respondent number, just say that now the sole respondent. Now the sole respondent.
But insofar as office objection is concerned, I have already uploaded that memo.
You have done that?
Yes.
When did you do that?
That this is done on 17th March.
17th March. Okay, just check up. Next, give a date.
16-6.
Much obliged.
Serial number 20. Yes, Jason.
For the respondent, your lordship,
Your Lordship, pray for a Passover. Lord, 20 is that matter in which your Lordships had heard for a short while earlier. The only issue is whether a proprietary concern represented by the proprietor could file an arbitration petition for adjudication of dispute.
Passovers. Nice.
Was appear for the respondent minutes. The respondent also filed an appeal minutes. It was also listed today, but however, minutes it listed on account of the fact that it is a subsequently filed appeal minutes 875 of 2025. It is listed before Court Hall 1. May I?
Where is the pending?
Court Hall 1
Court
is
Hall
listed today, minutes. Both were to be listed. Both were directed to be listed today, minutes.
So we will send it there.
No, Milaj, my humble submission is this is a prior appeal, Milaj.
No, but
That, Milaj, is an appeal
which
relating
is,
to,
no, this, what is the number?
this is 7366 of 22, Milaj.
Is this 21. Now, what is the appeal number?
Milaj, the appeal number there is, Milaj, 875 of 2025.
So, ma'am, this will go there. This will, I know. We'll send it there. Just say that we will list it along with that. It's in Court Hall 1,
And I'll make a submission today, Milaj, before Court Hall 1, Milaj, that this being a prior appeal, it may be sent here. Milaj.
We will say it. What is the day? What is the date given in that?
Posted today,
Today,
Milaj,
Milaj.
listed, both were to be listed together, Milaj, on account of the change in the
Where is the order? Show us the order where it's, okay, we'll see that. Where is the order to be listed along with this?
FA number 875 of 2025, where
Oh,
I am
because it got separated.
separated.
So just show. No, but tell us one thing. Where is the connected MFA being listed? Separately. Separate. Yes, we have been informed by the learner counsel for the, you also agree?
Yes, my lord, they both are.
By the counsel for the parties that same order arising from the same impute
Same
order.
award, Milaj. Same award and same order. Milaj.
That another appeal being MFA number
875 of
875 of
2025.
875 of 2025.
Yes.
Arising from the same impugned order is listed before court number 1, before the bench presided by the Honorable the Chief Justice. That is court number 1 today. If that be so, comma, this appeal shall also be listed along with the appeal, along with the aforesaid appeal before the, appeal, just say that along with that appeal, subject to the order, no, just along with that appeal. Okay, that is before court number 1. I just say before, along with that appeal. Okay, just send it. I'll just give a date.
Yes.
Next week.
May I request 2 weeks, Milaj? The reason is they only last night they filed objections to my condemnation.
weeks.
Last night they served.
2 weeks.
Much.
9-4,
Much.
serial number 22.
I appeal for the appellant. This appeal is connected with commercial appeal 438 of 23, my lords.
Yes.
Lord, this appeal is connected with commercial appeal 438 of 23.
When is that listed?
My lord, on the last month it was listed.
438.
Yes, my lord, commercial appeal 438 of 23.
What is the date there?
I don't know the exact date.
You have the date?
I don't know the exact date when it was listed before this court, my lord.
No, when is the next date?
It appears no date was given, my lords.
Just say that it's also 23.
Yes, my lords, 23.
That also.
Arising out of the same order, my lords.
Decree holder has preferred this
Then-
appeal.
No, who is the appellant there?
Appellant one Shantappa,
That's a cross appeal.
cross appeal.
Then you get it on list on that day. We'll just simply re-notify this appeal.
Please.
See, that's how now.
In fact, there was an order in that appeal to connect this matter along with that appeal.
We don't know. Just say that at the request of counsel for the appellant, re-notify all. Now you may have to take steps to get that appeal also listed with this,
It is before this court only. I'll do that.
or whatever is there. Next,
18-6. 23. Serial number 23.
Waiting for appellant in this matter, madam. Mainly have to next week, madam. Senior some inconvenience.
at the request of the counsel for the appellant, adjourn to, just give it June.
25-6.
Okay.
Serial number 24.
I'm appealing for the appellant in this matter, my lord.
Hmm?
Because I request for a short accommodation in this matter, my lord. I
Who
want
is
to
the other
engage.
side?
I appear for this,
What do you say?
that I filed an application for vacating the interim order.
My lords, I want to engage the services of a senior counsel, my lords. So I would request a short accommodation on that.
Suit is for specific performance. It is ordered to refund the amount that I have already deposited the amount before the trial court.
You,
My lords,
and
the fact-
with a direction for executing the sale deed.
No, it is not for executing
For the-
sale deed,
for the
my lord.
refund
It
of
is
the
for
amount.
refund the non-refundable amount
Oh,
with the other 2 crores 55 lakh. I have already deposited.
at the request of counsel for the appellant, adjourn to.
25-6.
My lords, interim order may be extended.
Interim order, if any, to continue.
That is the
Obliged, my lords.
date may kindly be fixed because that by your sure that 25.
We have fixed a
Obliged.
date.
Please.
Obliged.
25. Serial number 25. Srina Kirti.
Appear for the,
Yes.
appear for the plan. Your lordship, last occasion, your lordship directed me to ascertain whether we have filed the return statement or not. We are not filed the return statement, your lordship, there before the trial court. Only we filed the application for that, since the arbitration clause is there. The trial court rejected only on the ground that section 80 is not complied. We are not filed the original agreement.
Hmm. Section 8 rejected.
Only on the ground that only photocopy has been produced. Original copy of the agreement is not.
So what do you say?
No, your lordship, the agreement, original agreement with me only. I'm ready to pay, but court is not. Only my argument is that section 8
The other side.
caveat, they filed the caveat.
But did you file return statement
No, your lordship.
today?
No, your lordship. There also, because since their file also an application under Article 39 Rule 1 and 2 for seeking for the injunction. Their application is rejected. They also prefer the
So till date, you have not filed return statement.
till date, your lordship, because since their injunction application is rejected, they only taken the time.
But today they have filed an appeal against that.
They already filed the appeal against that rejection of injunction. Suit is for that, your lordship, they sought for the specific performance for the extension of the lease agreement which was expired. My contention is that, your lordship, in the year 2024, March 2024
Is
itself,
anyone appearing for the other side?
they filed the caveat and also they served the copy of the objection. But
So Gopi Prakash appears.
Gopchi, we served the copy and also
The
they
trial court doesn't contest, there is no arbitration clause by saying that photocopy. Why did you file a photocopy?
No, along with the application, because we are under the impression that your lordship section 8 comes only.
Did you take the original with him, with you to show it to the court? This is the original.
No, court is not at the course of the court is not at all raised that issue. Neither other side is also not raised that.
Who has raised this issue?
Only at the time of the passing of the order, the same has been.
But this was not an issue.
Not a issue before. Even though if this honorable court set aside that order remand, I'll ready to produce the original.
Where is the counsel? Pass over. Just call him.
Your lordship, I'll intimate them today. I am not seen him. Your lordship, any other day I will
Then none
intimate
for
him
the
also.
respondent. Re-notify on.
25-6. Serial number 26, Shri Som Sundar Rao. 26.
Pray for time.
Yes, Mr. Sundarao, tell us.
Because,
This is the same.
no. I did not seek. Another case is there, 28. I will argue that matter fully. At 26, I want to.
No, you argue both. Why only one?
No, I am not ready because I.
Okay, let's go to the next one first.
That's 28 is mine.
Just argue. Who is in 27?
I don't know.
MC Basuraj.
MC Basura. Yes.
Okay, let's see in 28.
So, Lordship, my case.
What are the subject matter of challenge? Dismissal?
Dismissal, correct.
On what ground?
And he is producing fake transfer certificate at the time of.
Fake certificate of?
School, fake certificate of transfer, fake certificate.
Pardon?
Transfer. Yes, workman producing fake transfer certificate.
No, but-
Because he is appointed as a driver at the time of selecting, he was producing original certificate along with others document. But their contention is, it is a fake transfer certificate producing and that is
Transfer certificate is that you are transferred from one place to another.
correct.
So you rely upon that certificate to get transferred to another place.
But their contention is that they did not study in that particular school. That is their contention.
Oh, school.
Yes. At the time of producing, at the time of appointment is 1992. He as a driver, selecting as a driver, certain document producing, all the document after verified and they have allotted the duty. Lordship may kindly see.
Where is your certificate? Let us see.
That's correct. Lordship may kindly see first award in favor of the workmen.
Which school you studied?
Vinayaka School, Cottonpet, I am studied. But their contention is Vinayaka School, there is no Vinayaka School, Cottonpet. There is school of Vinayaka School, Kabbanpet. They went there and ascertain where all the document produced before then.
Let's see the certificate.
Correct.
Where is Cottonpet?
Cottonpet in Avni Road. It is in Mysore Bank near Cottonpet. There is a circle. It is an old school. But Kabbanpet is here. That Mysore Bank and certain school, there is an adjoining the court.
Let's see the certificate.
Lordship may kindly see. What is that happens? Page
Mr. Sundarao, tell us where is the certificate, transfer certificate?
Produce that before the management.
Where is ours? We should also see.
I didn't.
So which class he studied at?
Fourth standard.
What is the minimum? What is the qualification?
Fourth standard.
For driver?
Driver for you say they required fourth standard.
That's all.
That's all. Fourth standard, alva? Eighth standard. Up to eighth standard.
Now,
The requirement is only for fourth standard.
no, this certificate was for fourth standard.
No, eighth standard. Eighth standard. Eighth pattern.
Where is the certificate?
No, I didn't obtain because original is in the transfer to labor court. I applied and obtained all the documents.
Let's see now, where is the certificate, Mr. See, you should have filed.
No, I filed, correct. I got only one marked before the court.
See, if you will not argue this matter, we'll go back to the other matter. We will hear you in that.
But
What is the finding of the labor court?
on labor court dismissed from the,
What is the finding on this? And was there any inquiry held?
yes, inquiry held.
What is the finding of the inquiry officer?
No, I considered the inquiry before the labor court. I filed a memo stating that, Lordship may kindly say, I read this para, only one para.
You conceded the,
Yes, fairness, issue number 1 is conceded.
what was the issue number 1?
One is whether the domestic inquiry conducted by the management is fair and proper. That is the issues. That is the issue. Next,
On the charge,
on the charge producing fake certificate.
you accepted that?
No, I'm not expert, denied. I'm not, my total, Lordship may kindly see, page, Lordship may kindly see, page 83. Page 73, Annexure B. There are some number of issues framed by the labor court. First award, subsequent award is, there is a second award is there. First award in favor of the workmen. Lordship may kindly,
Where is the second award?
second award, Lordship may kindly see, 43, I also, Annexure A, 41 page.
Now read this.
This is very important.
What were the issues framed?
They framing the issues, Lordship may page 20, page 46. Whether the second party management proves that the domestic inquiry held against the first party workman is fair and proper and in adherence to the principle of natural justice. Whether the second party management justify the finding of the inquiry officer holding the first party workman guilt of the charge level. Whether the first party applicant proves that order dated 10/8/2010 passed by the second party management dismissing him from service is perverse and bad in law. And as such, the same is liable to be set aside. To what relief the first party applicant is entitled to for what order? Additional issues frame again, whether after remanding, whether the first part after.
Tell us one thing.
Yes.
Why did you produce transfer certificate? The eligibility is 4th class.
Yes.
You should produce a 4th class certificate having.
There is, as per this circular, you can produce any, up to 4th standard is requirement, but you can study it up to 8th standard.
Where is the 8th standard certificate?
I don't have the certificate. I have. There is no.
Now the trans.
22. I think it is producing 19, the certificate bearing number is 1982. That, yeah. 92.
Where is the finding of the inquiry officer?
That consider once it is, there is no finding at all, because I read this, because the Lordship may kindly pay, issue number 3 and 4, page 50. I read this. Since the above 3 issues are interlinked with each other, the finding on additional issue number 2 has got direct bearing on the merit of issue number 3, and for the sake of convenience, they are taken up together for consideration. The fact that the first party applicant was member of the union is very much manifest from the certificate produced exhibit W5. Certificate issued by the joint secretary of the union stating that the first party workman is a member of the union from the date of joining to service till the date of dismissal from his service. Admitted case at the staff and workers union put demands before the management, and the management failed to respond positively to their demands. Dispute came to be raised by the union before the labor court, conciliation officer. And such conciliation officer failed. The government referred the dispute to the industrial tribunal by charter of demand. And such in reference before being referred in the court. The same has been registered ID number 148/2005, and the same is pending adjudication on the file of the said court is not disputed from the said of the second party management. When the first party applicant is a member of the KSRTC Staff and Workers Federation as per the W5, and charter of demands was placed before the management, which is the subject matter of ID number 148/2005, involving large interest of workmen and other workmen of KSRTC and allied corporation link BMTC, and such the first party applicant would be benefited ID number so and so allowed, and the same is rejected. His interest would be affected. So there is no justification on the part of the second party management to contend that the workman is not concerned to the dispute in ID number. It is also not in dispute from the side of the second party management that petition under section 33(2)(b) of the Industrial Dispute Act 1947 has not been filed by the management in ID number seeking approval of the dismissal order by the said court. But to overcome the same, the learned counsel for the second party management has relied on the recent unreported decision dated at 16/2/2011 of our own Honorable High Court in writ petition number 46/544 of 2011, where the petitioner was dismissed from service for the misconduct of getting employment on the basis of the fake transfer certificate. In the above unreported decision, His Lordship has observed that the petitioner did not have the requisite qualification to be appointed as a driver in the respondent organization, since the transfer certificate was proved to be false, containing wrong information over his qualification, and therefore the termination of the employment does not tantamount to termination for a misconduct not connected with the dispute in ID number 148/2005, calling for approval of termination under 33(2)(b) of the ID Act. So in the instant case, this is very important. In the instant case, WW1 has deposit that he entered into service during the year 1992, and thereafter he was confirmed in the post of driver in 1999, and he was put in 19 years of continuous service, and based on the allegation that he gained employment by producing bogus transfer certificate. The second party management has initiated domestic inquiry and illegally removed from his service. And so the action of the second party amount to unfair labor practice and malified exercise of the powers. So further, deposit that the second party management has issued a circular instruction that the allegation of furnishing bogus transfer certificate or false information should be detected before completion of probationary period, and action should be taken before confirming the employee into the post for which he was selected, and the second party management has grossly violated their own circular instruction dated 2/28/2003, and further the circular dated 13/8/2001, the disciplinary authority in the matter of imposing punishment, imposing order of dismissal should not give scope for dissimilar and varied punishment as far as possible for similar and like offense committed by a hiring employee. And in spite of said circular, the disciplinary authority has imposed the extreme penalty of dismissal, and in similar and in identical cases, the second party management has imposed lesser punishment and continued the employee in service of the corporation. So the dismissal order is not in accordance with law. Lordship may kindly see in a Supreme Court in Ramu case, and also circular issued by the corporation. That is rendered by judgment in division bench in this honorable court. It is in favor of the workmen. The circular has not, there is a clear cut before probationary, completing, he has been removed. After completion of the issued by the dismissal, confirmation order, you cannot initiate any action. That is there in the division bench, division bench case. In a similar matter, suppose a person who has, I have marked before the court several WW1 to WW4 in a lesser punishment order. There is a discrimination. Yes, the
The charge there.
What's the lordship?
What was the charge there?
In an identical charge, there are the producing.
Where is the case? Show us.
That market, those documents are there by punishment, lesser punishment. I have marked before the lesser court. Those documents are marked. Therefore, lordship, I read documents. The documents is produced and before the labor court at the time of workman was evidence led WW1 to WW4.
Mr. Rao, when
Yes.
we are deciding it, we should see it.
Yes, sir. Lordship, I didn't have not applied for those documents.
You don't.
Lordship, sorry. Because I applied. If you want to go till, I'll show that.
You don't file any document you want us to decide.
Now I file it.
What is the use? Tell us.
Lordship, again,
Documents should have been.
correct. I will submit produce a application and seeking the documents. Entire documents I will produce. WW1 to WW5. What document has produced?
Did you produce before the learned single judge?
No, I didn't produce. Because the labor court disclosure, even lordship may kindly see last page.
Should we hear you tell us? Why should we hear you?
No, because so it was taken in the, lordship may in favor of first award. Lordship may kindly see first award. Because
We will not see the first award.
evidence is there. That is the matter that both sides did not let evidence. Therefore, the second subsequent award, the labor court did not disclose also those documents in the award. It is, see, marking up the documents, lordship may kindly see W1 to W4 copies of minor punishment order, consent to other 4 workers, certificate issued by case at the staff and workers. These are the
What was the charge?
charge is bogus transfer certificate produced and obtained. The disciplinary authority give lesser punishment and again reinstate the workmen, and they are all work until the retirement. That is the copies of minor punishment. Minor punishment imposed by the disciplinary authority is all bogus, same identical charges.
Tell us, with this charge,
Yes, lordship.
is it justified? Is it justified?
No, their management has not justified because I have studied in Contempt in Vinayaka school. But why did the management went to Contempt school? What is the reason? The records are not available in Kadri. Lordship may kindly see. It is there.
Is it still there, that school?
Now that school is there, because now not there.
Is it there or not there? You say both.
No, not there now. After
Why is it not there?
after something is closed because there is a certain taken lease also. It is an old school.
When was it closed?
At the day they went to 1984. 1994, 94, 93. It was not there.
But before you took that certificate, it was there.
Yes. There my certificate bearing number is different. There Vinayaka school certificate. Lordship, that's exactly.
We are anxious to see that certificate.
Yes, I will apply for a certificate and bring that all.
Just say the request of.
And also, Lordship may kindly say, Lordship, it is I have at the time of original I have produced, but they have produced marked before the inquiry officer, it is a Xerox copy. Therefore, it is their contention, that discloses in the contention, that contention.
Maybe origin, who has marked it?
That management. While at the time of selecting the person, I have produced those all document original. Original with their management custody. Why did you produce Xerox copy? And mark it, whether it is a permissible under section Evidence Act that those documents.
It can so happen, original seen and returned.
No, they have not returned.
No. When the marking takes place.
Correct.
The original is produced.
Before the inquiry officer.
Before, very well, before the inquiry.
Hmm.
Original is produced.
Produced, I will hang back, given 92 at the time of joining, I handed over all the documents. So far, they did not hand it over me. Till it is there because I am working for the driver as a driver in 19 years.
We want to know when was it closed?
There, it is their contention. I was one Talwar was the security inspector, went there and there is no school. They went to there and Vinayaka school. Why they Vinayaka school went there and obtained all the document? There is no such he has not studied. Whether what is the purpose? They went there. If it is not school there, suppose they transfer to some other school, the children are transferred to some other school and maybe possibilities there.
Okay, produce.
Very well.
At the request of Mr. Sundar Rao to produce.
Som Sundar.
Som Sundar,
Yes,
sorry,
sir.
Som Sundar. Som Sundar Rao.
Rao, yes.
But I was right.
Right.
Produce the complete record of the labor court.
Yes.
On the next date of hearing, re-notify. Just give it in June.
There is a direct judgment in favor of the workmen. 3 judgment. One is division bench, Supreme Court in a similar, dissimilar.
In 6.
What is the proposition?
Proposition is section 11A invoking and lesser punishment, give 2 increment or 1 increment.
There are many judgments on that, Mr. Rao.
Correct, sir.
Depends upon charge, depends upon gravity,
Correct, sir.
depends upon evidence,
Yes,
many
sir.
things.
Correct,
Okay.
sir. Because I am a permanent employee, where I was a age barred, where available some other job in some other institution. Because age bar, I have got 2 children. He has worked somewhere, they did not work so far. I am not a gainful employee.
Okay, next.
Date
We'll come back after
18/6.
18 June.
18 June. I directly produce here only, or I said that, sir. All the documents, sir.
Produced, file it in the registry.
Okay.
One submission.
Yes, Mr. Ola.
Serial number 29 and 30, my lord. Maybe
Yes.
take up next week, my lord. Because
Pardon?
some inconvenience for me in the afternoon. 29 and 30, my lord. serial
What
number.
is the issue?
Issue CIT matters, my lord. this one. The first matter, my lord, regarding my Eastern application has been rejected, not on merits.
For what? What is the issue?
Issue is regarding the higher pay scales under the court. But the tribunal has said you have to give representation, then only you can approach CIT. That's why it shows the improved order, my lord, it's applicable to us.
On that ground rejected.
Yes, my lord.
We'll send it back,
It's
Mr.
applicable,
Pramod.
my lord.
Only on this ground.
Locus standi, it was, what is challenged, impugned is pertain to some other person, Annexure A15. It is not given to the applicant as such. It is in some other matter given to the tribunal head. That they don't have locus standi to challenge that order. And also hence what is mentioned over there. That's what the point.
Why don't you go back, file a representation?
Impugn order says, except 6 persons, others will be given will not be given this benefit. That means others are excluded. We include the cameraman, my lord.
Okay.
Both the matters.
We'll come back after.
With the lordship's guidance. Serial number 32, I pay for the petitioners
32.
32 minutes. It's a batch of matter minutes. I am appearing for all the petitioners minutes. My name.
We are ready.
But AG is not there today.
Okay, wherever
And
there are
the other side
32 also adjourn. 32 and 28, 29, 29, 30. Mr. Ola adjourn. Yes, any other adjournment?
Maybe this matter 32, refixation of the re-employed ex-serviceman in this matter.
Any
So
date.
he wants
minutes.
time.
I have informed, my lord.
Any start date may be fixed, my lord.
Any date may be fixed, my lord.
We are
The first
fixing
week
it.
or second
Yes,
week of
June,
April.
April if it's possible. Any date. Today also we are ready, my lord, but they are sick. I represent the respondent, my lord. According to us, it is covered by extension of the.
What do you say?
Not covered, my lords. It's applicants are the ex-servicemen, my lords.
You know, right.
And pension, my lords, they're getting pension.
So
So
it need to be ignored,
that has to be ignored and fixed, my lords, as the entry pay which is fixed to that.
but minimum of the pay scale.
Please, please.
But then issue must be covered. There are so much of litigation on this. Supreme Court also. There's so much.
Other statutory organization. ICA.
But that depends upon rules. This is which organization?
This is, my lords, railways, my lords.
When do you want?
Lords, in the second week of April.
Just give it in April's last week. Last week.
My lords, serial number 6, my lord, it is passed over. My lord, second half, my lords, arguing counsel has a medical appointment, my lord, request for a date on Tuesday. My lord, Maitri Krishna, we will inform, my lord.
Should inform.
Yes, please, my lord. we'll inform.
Come back after lunch. Just tell him, come back after
Please,
lunch.
please, my lord.
may I? I've been informed that serial number 6, they have taken an.
My lords, I appear
adjournment.
for the appellant, my lord. We have informed the other side, my lord. Oh, sorry, respondents.
Please, my lord, was passed. Please. Please. My lord, they've said that Mr. Saukar is not they
My
available
lords,
today
he has-
afternoon.
Afternoon, my lords, he has a medical appointment, my lord. I'm informed.
My lord, may I request for the first week of April, my lords have already heard this matter.
Madam.
Grateful. My lords, may I request for
Grateful.
2:30 on 8th, since my lords has heard this matter, if it may be concluded on that day. If it is convenient to my lords. Please. Please. Please, most grateful.
Grateful, my lord.
Twenty-six. Twenty-six. Till number 27, Shri Basuraj, MC Basuraj. 27. Thirty-one. Till number 30. 31.
It's 31, my lord. I appeal for the respondent. Yes. Not appear for the respondent in this matter. Yes.
Urgent, sir. 30. 33.
Sorry, my lord. 31. Yes, ma'am. It's an order challenging, so sorry, my lord. The order passed by the Honorable Central Administration, 31. Yes, so sorry. Yes. He says that he is entitled for the grade pay of 5,400. According to us, he is not entitled, and he has been granted all the three financial benefits under the ACP and MSCP. And he says, I have been in the kind of 4,800 for 4 years. I am entitled as per the government resolution, which does not apply to him, and that's what our contention. He has been given all the three MSCPs. He says, in grade pay of 4,800, I am there for 4 years. I am entitled for 5,400. That is what is the land tribunal. That is what the issue. No, that is not the issue, my lord. Issue is on completion of Group B officer, on completion of 4,800 grade pay, on completion of 4 years, he is entitled to be granted with 5,400 grade pay. How did you get 4,800? 4,800 by virtue of ACP, MACP, and regardless of that, my lord. Sorry, you shall. Promotion as 4,008. Where after 4 years, you will get 5,000. It's like it's a selection grade sort of a thing.
Non-functional selection rate.
Well, this is no way linked to SAP, MACP. That is what the Honorable Apex Court.
Actually that. But if you read and look how you got 4,800, that 4,800 to get as a promotion, then it is non-selection, non-functional selection grade. After 4 years, when you get 5,400.
May I make one submission, madam?
Yes.
If the lordship could see page number 118 of the writ petition.
Give us to be a gentleman on this.
I'll make my submission. One one eight, madam. Last paragraph.
118.
118, madam. Internal page 13. 118 is the page wherein the order of the Union of India and others versus Arbinda Patak and others passed by Honorable High Court of Calcutta is reproduced, my lord. May I read, my lord? 113 page, last paragraph, operating. We do not find any justification in the stand of Union of India and the benefit of successfully rendering service for 4 years was done away with upon introduction of the MACP in the year 2009. The moment the respondents have fulfilled the criterion enshrined in paragraph XE of the resolution dated 29/8/2008, we do not find any justification in the stand of the Union of India in denying the benefit thereunder. The said scheme was extended to the Department of Posts and admittedly the respondents or the Group D officers in the said department. The authorities therefore acted contrary to the law laid down by the Madras High Court in Subramaniam Supra in rejecting the representation.
Where does this gentleman get 4,000? We just have one page before that.
My lord.
The challenge to the clarification issue. Capital Ministry of Finance clarifying non-functional grade pay of 5,400. That's what we are saying. Now shall tell us, in this case, the gentleman got 4,800 as an MACP.
That was the issue, my lord.
This was in the context of actual promotion and getting 5,400 as a non-selection.
Yes, ma'am.
Non-functional selection.
Yes, ma'am. The order of the Calcutta High Court is at page number 49, ma'am. Yes. That is the issue. This went up to the Honorable Apex Court and Apex Court has dismissed the CA 888-3 of 21 filed by the Union of India and the revision filed also was dismissed. Thereby the matter attained finality. The only two essential ingredients is a Group B officer who has completed 4 years in grade pay is entitled to be granted with grade pay of 5,400. That is the main.
Manoj, this is not the case. I'll just explain. Manoj, that I would like to explain. Each employee and his recruitment cadre, it requires to be looked into. It is not, yes.
Since your scheme, your Union of India, everything it will be available.
There also, Manoj.
We hear it once, it has attained calculated.
No, Manoj, that is not the issue, Manoj. I'll just, may I request Manoj to place it? According to me, it is not.
Based on Calcutta. Say the matter into Supreme Court of the law.
No, that is not.
Even it is recorded at page number para 6 of the chat's judgment, my lord. Page number 111.
Keeps it only on this basis.
Yes, my lord. They have culled out the entire.
This is Department of Posts and Revenue. There are 3 other departments. The CAT category held that this employee is belonging to Department of Posts. There are 3 departments. That is the issue, my lords, because there again, my lords, that resolution pertain to 3 departments. Can you, this, the honorable cat in paragraph 6 holds that there is no dispute, this employee, the applicant is Group B officer of Department of Posts. But different recruitment rules made applicable for each and every department, as well as cadre also. Yes, 118. We do not find any justification in the stand of the Union of India that the benefit of successfully rendering service for 4 years was done away with upon introduction of the MACP in the year 2009. The moment the respondents have fulfilled the criteria enshrined in paragraph 10E of the resolution dated 29/8/2008, we do not find any justification in the stand of the Union of India in.
It is at page number. It is there, man. Page number 49, my lord. Sorry.
49.
Is at page number 53, man. Page number 53, man. 53, annexure 11 of the OA. The operating portion is at 59. Man. Yes, ma'am.
But Calcutta it is
Para 8 may be looked into.
my instructions are that minutes the class case between the applicant, respondent and the referred does not go in the same stand. Reason is this, my lords. Kindly see the appointment of the respondent and the grant of ACP and MACPs and the recruitment rules applicable to him. The pay, grade pay, what is to be held initially, it's been in the
4,800.
yes, ma'am.
That's
what.
Yes.
In this case, according to my instruction, it is not applicable. For this, there two aspects are there, Manats. May I request one? No, Manats, it's not the case. May I request only one short accommodation, Manats? I'll Monday or Tuesday, I will get this. No, Manats, I will give the correct picture about the this information itself. That's I get. I will get it. My instruction, Manats, they discussed with me. They said that it's not applicable. I'll just place it on record and close it.
They have said
that Union of India has said that stand has been negative. That's what the reasoning given by the judgment of the Calcutta High Court, Manats. Yes. Now, what I am trying to say is, Manats, the factual background of that matter, I would like to examine and make it submission on. Yes, sir. $57, $55, I'll just read. That's first paragraph, Mansa. The authority negated the claim upon placing reliance upon a scheme of MACP introduced on 18/9/2009. wherein the upgradation in the grade pay can only be provided upon completion of 10, 20, 30 years of service in a cadre. It is thus indicated that though the sixth pay commission recommended the enhancement of the grade pay at rupees 5,400 upon completion of 4 years of service at 4,800 at the Group B cadre, the same had never been extended to any other Group B officers. Since the petitioner took a plea that the similarly circumstanced persons had been granted the benefit under the said resolution dated 29/8 by the Hyderabad of the CAT. The authority is taking a clue from the observations made therein that the said order shall not be treated as taken by the Union of India, that since the MACP has been introduced in the mentioned meantime and there is no decision of granting benefit on the said resolution dated 29/8/2008, the respondents are not entitled to any benefit. In fact, the identical issue was raised before the Madras High Court in the case of Subramaniam versus Union of India and others in WB number so and so, wherein a plea was taken that once the benefit under the MACP has already been availed, the same cannot be re-extended in terms of the recommendation of the Sixth Pay Commission. The Madras High Court, shall draw my Lordship's attention, this, when it was introduced, in this case, that grade pay has been paid in the year 2019. Now, that whatever was entitled when it was introduced, that makes a difference. Yes.
After exactly 4 years, you make my grade pay.
His case is not, stands in a different way for this reason. His 4,800 came in the 2019, not in the year 2008 or 9, in the interregnum of introducing that 2019 man. 19. No, that can't be manner. This reason, first is that the Madras High Court and the Calcutta High Court judgment is persons who were at that juncture when the Sixth Pay Commission was introduced. Not at this. I need only one short accommodation. I'll place it on record tomorrow. I'll just, could you, day after tomorrow, 20%. Day after. Friday. Or else Monday. Tomorrow. I will clarify that position, Manas. I'll clarify that position. I understood, Manas. Lordship, what? Yes. I have to distinguish the fact of this case and those cases and what was the ratio laid down and what context I'll explain. According to my. Yes. But the factually differs. That will take it.
Much obliged, man.
Obliged.
Serial number 33, Sri Shanti Bhushan.
Bonding. Like.
Thirty-four. Serial number 34.
This is a matter where the award has been set aside by the learned single judge and not single judge, not the learned civil court. But Gayatri Balswamy Constitution Bench is now reserved on this point as to whether this power is there and if at all, whether there is power of severance. So, my respectful submission. would
Well,
be
the
that.
Constitution Bench has heard the matter and reserved on that issue. But there are. No, there are two appeals. I mean, we'll wait for the outcome of the judgment. And until then, if nothing is precipitated, I'm all right.
Got it.
Like this, 5 claims.
Please.
Appearance is made with 2 claims, not by the 3. Permissible? Yes. Permissible. Civilly. Arbitrator award X amount. The people court says not X amount, it should be X plus Y. That is not permissible. See, these are eventualities. I have seen 34 orders where the relief itself has been changed. In the sense, X plus Y should be the, or X minus Y should be the. That is the case before us. It's possible. See, if there are no reasoning, there can be justification in 34. There is no reasoning. Of this particular aspect has not been considered. So this amount could not have been given. Something less should have been given. This is one eventuality. There are so many eventualities. But there is one eventuality. Suppose any finding of fact on a particular claim would have a bearing on the connected claim. Okay. Then in that eventuality, can there be an interference in the finding of fact which has a bearing on the connected claim? Unless that finding of fact is set aside, this cannot be tinkered. But they say if that is upheld, this must be upheld. Even though palpably, even though the conclusion of maybe the claim has been, maybe there is an exaggeration or a higher amount has been given, it is not upheld. There can be many eventualities, like what is being done under the RFA. RFA is it's as wide as, but the court said these are not RFAs, these are not appeals. Well, I watched the arguments to advance before the Constitution Bench. They were on a very thin line in terms of modification. Very limited jurisdiction. I mean, as the arguments have advanced, even on common ground, even on the petitioners who wanted to empower the court under Section 34 to modify an award, their line of argument was a very narrow scope. It would not serve anybody's purpose or justice in remitting the matter back or remanding the matter back to the arbitrator. Right? Clarify. Everything is settled at 34 level. Right. Otherwise, what will in today's regime, suppose 34 court is not convinced on a particular aspect, it can't set aside, it can't modify, either set aside or upheld. Very interesting. 5 claims, 2 claims are palpably perverse. But the law is either you will set aside or uphold. Though two claims need to be set aside, but the award cannot be tinkered with. It will be upheld or set aside. On that basis, the whole of the award, including these 2 awards, are being upheld. May I make the submission? I mean, I quite appreciate what my lord had. In terms of partial setting aside, that has never been an issue. I don't know that possible. You are right.
Exactly. My lord's illustration, there's no, yeah. No difficulty, no difficulty at all.
Both two are palpably wrong, but you will not set aside those because you can, either you will completely uphold or completely set aside. That's another.
You throw out the baby and the bathtub together.
That's it. So courts have been doing, we are getting this jurisdiction also, like this one. We are getting this jurisdiction. The argument is that even if two are palpably wrong, either you have to set aside the complete arbitral tribunal, the award, or uphold it. But you can't segregate it. Three upheld, two set aside. You can't do it.
What has happened, my lord, in the appeals before? This honorable court. The learned judge in disposing of the 34 has left no award. He's left a decree of his own. I'm just bringing to the lord's attention. Even that 3 and 2 doesn't work here. Yeah.
If on a finding of an issue at the same time, if there is one argument, then you can revoke the arbitration clause and start the proceeding separation. Then question would be whether principles of res judicata would be applicable. Because it can be this way on an issue. There is a finding of fact which has been upheld in 34. But award set aside. Can you revoke the arbitration? When there is a finality on certain finding of fact. But on a technicality, it has been set aside. It can be said, okay, you revoke the arbitration clause and proceed accordingly. Then all the rigors of limitation, all those things will come in.
That's right.
Well, there is a difference in fact. First invocation was 10 years back, and the second invocation is after 10 years back. Limitation would come. There can be a limit. Let's wait.
Please. We believe that the order will be expected in a couple of weeks, my lord.
So the CGI was part of the.
That's right.
Yes.
9/4. There is an execution which is pending. My friend I should be glad he said he'll not precipitate the matter.
Last time I had said it.
9th April is the hearing date.
My only request is, they have been asked more than once by this honorable court, say, how much are you willing to deposit? Even going by the award, not by the 34 order. By the award, it's 1.8 crore due. But they have not deposited a single paisa.
No, the difficulty is this.
Even going by the award.
No, we have advanced this every time we come before my lord, and we don't want to trouble the court on this. My lord, we have certain arguments on this. We don't have an award in place today. What we have is a judgment and decree of a court.
Therefore, Lord, I'll go ahead with the execution.
in that case.
Please. I'll do that. Last time also I did that. Lord, let him deposit something to show his bona fides.
What he says, what to be done.
Lord, I follow. Lord, my respectful submission is,
May I make this?
he
Difficulty is this.
has not sought for stay.
We moved an application before the trial court saying that it is a nullity. And it's an odd situation where we have an appeal pending before my lord's court. And we are telling the executing court in the absence of a stay. Therefore, to avoid any embarrassment to any of the courts. Yes, exactly.
Please. Please. Last time I did that.
We'll expect my friend to follow the same course of action.
24.
My juniors. No, I understand. I understand, my lord. I understand completely. We want to be fair to the court.
Please.
24.
Very grateful.
Great.
Past door matters. Serial number 11.
Please, your lordship. I beg your. Question is
11.
your. Lord, the learned single judge's order is challenged.
11.
Lord,
Serial
whereby
number 11.
he had interfered in an arbitration proceedings, Lord, in an award passed by the collector under the National Highways Act. Lord, he set aside the, Lord, according to me,
24/4.
Yes, yes. Would your lordship kindly have a look at the order passed by the Principal Civil Court, my lord? Your lordship will get it at page 170. Yes, my lords, I appear for the appellant. Yes, my lords. National Highway Authority. Yes. Your lordship kindly have a look at page number. Yes, my lord, I shall, my lord, what happened is this. There was an acquisition proceeding. Thereafter, my lord, an order was passed by the competent authority fixing compensation under 3G51. Thereafter, my lord, dissatisfied by the order passed by the competent authority, the respondents herein invoked arbitration. No, my lord, it is before the collector. It's under the Arbitration Act. My lord, I just take your lordship to the provisions of the National Highways Act. Yes. By the competent authority. Yes. Yes, my lord. He's called the competent authority land acquisition. Yes. No, he's not the arbitrator, my lord. Competent authority is the authority who passes the first order. He fixes the compensation. If either of the parties are dissatisfied with the order passed by the competent authority, they can invoke arbitration under 3G53. My lord, the respondents herein invoked 3G53. My lord, the collector, after passed an award, according to the Arbitration Act, he passed an award. That award was challenged under 34. Lord, your lordship will see what was challenged under 34. Lord, according to us, the challenges, the provisions are circumscribed. You cannot challenge an order beyond the scope of 34. You can only challenge it within the parameters. But what they have challenged, what they have done, my lord, before the Principal Civil Court, they did not challenge it according to the provisions contained in 34. They said that they needed enhancement. They said that we are entitled to enhancement, and they raised all the grounds for enhancement. The learned Principal Civil Judge said that he does not have a jurisdiction because his jurisdiction under 34 is circumscribed. And therefore, he cannot pass an order enhancing compensation. He can only pass an order within the scope of Section 34. What did they do, my lord? They did not file a Section 37 petition. They came here, filed a writ petition before the learned single judge. The learned single judge, my lord, if your lordship were to go through the order, it amounts to, according to me, my lord, subject to what your lordship feels, according to me, it amounts to conferring jurisdiction on the Principal Civil Court, which does not have. He says that there is no discussion on the provisions of law. He simply says that he is satisfied. Yes. I'll take it. That's what I invited your lordship. Yes, he said that he does not have jurisdiction. The challenge is for enhancement for which he does not have jurisdiction under Section 34. He says that no grounds are raised under Section 34. However, they have asked for enhancement which he is not entitled to grant. Yeah. Yes, my lord.
Setting aside of the land acquisition officer award.
Oh, no, my lord. No, I think I got myself confused. Lord, the arbitration proceedings before the collector is an independent proceeding. If either of the parties, either the land acquisition officer or the claimant is dissatisfied with the order passed by the competent authority, he can invoke arbitration. My lord, there is no consideration of the award passed by the competent authority there. He independently, my lord, adjudicates on the claim. That's a claim. It's an arbitral claim. Yes. Therefore, my lord, he is an arbitrator. Only thing is, my lord, his appointment is made by the central government. That's a different matter altogether. But then he is an arbitrator for all purposes. Now he arbitrates between two parties. There is a list. Now he passes an award. My lord, that award can be challenged under Section 34. Now, my lord, what can be challenged under 34? The grounds under challenge is restricted to the provisions of contained in 34. You cannot ask for enhancement there. You can only say that the award is illegal, all those grounds. But what they did under 34, my lord, before the Principal Civil Judges, they came and asked for enhancement. That is the only ground raised. Now, the Principal District Judge said, under 34, I don't have the jurisdiction. And therefore, he dismissed the claim, the Section 34 petition. But they did not file a 37 before your lordships. If they had filed it, it would have come before your lordships straight away. But however, my lord, they chose a different path. They filed a writ petition saying that that they should be given enhanced compensation. The single judge, my lord, he does not go by the prayers in the writ petition or the grounds of challenge. He says that he confers, my lord, according to me, he confers a jurisdiction on the principal civil judge, which he does not have. Therefore, my lord, certain vested rights that we have pursuant to the order passed by the learned principal civil judge has been taken away. My lord, he's also said that the Limitation Act will not also not apply. Yeah, I'll just take your lordship to the single judge order. Lordship will get it page 22. Para 3, my lord, may I read? May I read, my lord? Being aggrieved, the petitioner preferred an application in that, so under section 34 of the Arbitration Conciliation Act. However, the learned second additional district judge, Tumkur, has proceeded to come to the conclusion that the application under section 34(2) of the Act was not maintainable and has proceeded to dismiss the same. In my view, the application filed under section 34(2) of the Act as against the award passed by the Deputy Commissioner would be maintainable, and the learned district judge was wrong in coming to the conclusion that such an application was not maintainable. Consequently, the order dated so-and-so, so-and-so was passed by the learned so-and-so, so-and-so is quashed, and the learned district judge is directed to consider the application of the petitioner afresh and decide the same on merits. However, the learned single judge shall not permit the question of delay to be raised by the respondents, since the petitioner was prosecuting this writ petition and the application filed by him under section 34(2) of the Act was within time. Yes, my lord. Yes.
Has been accepted by the learned civil judge.
Yes. Yes.
What he said is the district judge could not have come to a conclusion principle was not made.
Correct, my lord.
But he doesn't say in what manner it is not.
That is the difficulty, my lord. Yes, lord, what way? Oh, sorry.
Enhancement.
Yes.
That is not maintainable.
That is not maintainable, and the writ petition, my lord, these questions were not raised. This is purely, my lord, the judgment of the single judge. He does not go by the writ petition. If your lordship will see the writ petition, my lord, will your lordship kindly have a look at the praise. The praise are, my lord, for enhancement. The praise are for enhancement. I'll just take it. Yes, my lord, my lord, my question is, my lord, the powers of the learned, the court, my lord, the High Court has got powers under 226. But, my lord, your lordships have yourself restricted exercise of lordship's powers, and laid out principles when your lordships will exercise 226. My lord, this writ petition, according to me, my lord, does not come within any of those exceptions that your lordships have carved out. Yes. Correct, my lord. No, no, matter went to 34, it did not come to 30 under 37. No, after it's not, no, it is not gone. We have just come, my lord. It is not gone so far. Yes, it is not gone so far. Respondents, my lord, we have not served. No, we have not served. I'm sorry, my lord, we have not served. No, yes, we will serve, my lord. Your lordship may have.
Section 14 of the.
Yes, my lord. Yes. That's a different issue. I would only say this, my lord. Let the principal district judge adjudicate on issues where he has got jurisdiction. Section 14. All these things, my lord, it is within his domain. Lord, I am only saying that it may not be interfered in your lordship's supervisory powers. Yes, decided. Correct. Correct, my lord. Correct. They can come under 37. Yes, that is for them to work out their remedies, my lord. Not maintainable. Yes, that's all. The other things they have to work out, or we'll work it out, my lord. That is it. Maybe on the counsel who appeared in the trial. Yes, yes. Certainly.
Counsel may have, may not have instructions.
I understand. That is a normal practice. That's why I thought yes, I'm not from here, I'm from Bombay actually. Yes, yes. Yes. And in Bombay, my lord, that writ appeal will not come up before your lordships if we don't serve the other side. Without service, we can't bring it up. The rules are such. Lord, may I seek a short stay, my lord, of the order? If the arbitration, if it goes back. No, they have not so far, my lord, but they can any day. Yes, my lord, I will. I'm obliged.
24.
I'm obliged.
Manu, okay, 16.
Brief praxis. May I just set out the brief facts and the brief grounds on which I'm before my lords. Contract is for construction of a railway overbridge. Initially, it was 4 crores contract. Later on, my lord, a supplementary agreement was executed for the construction of the railway overbridge. The carriageway was increased. The notice to proceed was issued, but the possession could not be handed over as of that date. The markout date was on subsequent date. The contract period was for 9 months. The markout was given, possession was handed over. The work was, initially the contract was for 9 months. They completed the work in 14 months. The completion date, my lords, is in the year 2014, 5/2/2014. Thereafter, my lords, in 2018, after lapse of 3 years, an arbitration notice is issued. And the arbitrator's name is proposed. As per the arbitration clause in the contract, the standard contract, if the parties fail to agree, the power to nominate the arbitrator is with another 6 institutions. And thereafter, upon failure, can 11(6) be invoked. This is a case where there is upon me not agreeing with their nominee, they filed 11(6) application. And this honorable court they did not approach the 6 institutions enumerated in the schedule. Then, my lords, the person who was nominated by them himself has been appointed as the arbitrator. He is a retired engineer. Thereafter, my lords, claims are filed.
So they themselves have nominated the arbitrator.
They had suggested they had nominated an arbitrator under the notice. In the notice, the same person is appointed as the arbitrator. The contractor is appointed. They went to 11(6). In the 11(6), the same person was appointed by the single judge in excess. My lords, the person named in the arbitration notice, the invocation notice issued under section 21, the same person was nominated as the arbitrator in 11(6). By the Honorable High Court. So he was a retired engineer. He was a retired engineer. Yes, my lords. Now, yes, yes.
You can't bring in principles of pains, hostile fines.
I am not at that. I am.
So you proceed on the premise the arbitrator has been validly appointed.
Yes, yes, yes. I'm just highlighting this fact. Yes, my lords, the government advocate there had appeared. The had appeared. It was, my lords, what happened therein was that objections was not filed. And because objections was not filed, an appointment was done. On that. So insofar as my right to contest on whether the arbitration tribunal has been constituted in terms of the arbitration agreement or not, that would still survive before the tribunal, because the power, I will make that argument, my lord, when I reach there. Now, thereafter, my lords, the claim petitions were filed. All the claims except for the first claim are for compensated damages under Section 73 of the Contract Act. 7 communications, written letters, making certain allegations, and then 4 reminders. These are the documents placed before the Honorable Tribunal and 4 calculation sheets. And based on that, my lords, no oral evidence is laid. I did not have an opportunity to cross-examine the party. And on the basis of those calculation sheets that are placed before the Honorable Tribunal, an award comes to be passed. And in a few cases, there are like for overheads, there is a calculation pleaded by them in their claim petition. And I object to that. I file my statement of defense. I say this is a compensated damage. He must produce proof for having incurred that expenditure. Despite that, the arbitrator comes up with a new case for the claimant, wherein he applies certain formulas and says that and even though there is no evidence, I'm going to still grant the damages. Now, on that, my lords, I had the award came to be passed for about 4 crores with interest on 5 claims. I preferred Section 34. The very same grounds that I urged here were urged there. My lords, the issues that on which I would submit my arguments are. My lords. My lords. My lords, claim number, if my lords have page number, I have filed my paper book, my lords, in that page number 412, volume 2. Idling charges for machinery mobilized, idling charges for labor, expenditure incurred on overheads, price adjustment, and final bill. 2 bills, my lords, insofar as there are 2 bills in respect of which page number 412. Claim number 1 and 2 relate to final bill and price adjustment bill. We are faced with a unique scenario, my lords, in that the final bill and the price adjustment bill were never submitted to me at any point in time. During the comments, after the arbitral tribunal takes it in the claim petition, it is annexed for the first time. And the issue in their claim petition for the first time in the year 2020 for a contract that concluded in 2014. My lords, we said we have not received this final bill and the price adjustment bill. Notwithstanding that, the arbitrator comes to the conclusion that even though there may be a technical error, now he has filed. There are contentions that have taken up on limitation. There is no answer to that in the arbitral award, because each. Yes, my lords, I contested the bill saying this is not submitted. He is not entitled to it. No, my lords, no bills were payable. He had not submitted the final bill. For whatever work he had done, he has taken the payment. So, my lords, now the issue is, I will just point out what are the claims that have been raised. First one is final bill for the work executed. Second is the price adjustment bill. My lords will see claim number 2. Right? And then 4, 3 and 4. Idling charges for labor and machinery mobilized. Then item number 7, expenditure incurred on overheads. 2, 3, 4 and 7 are in the nature of Section 73 claims. 2, 3, 4 and 7. Yes. I'm at page number 412. Page number 412.
Yeah, we have.
2, 3, 4, and 7 are in the nature of section 73 damages. One is for recovery of money.
Charges for evidence you should.
My lords, for idle charges, it's they will have receipts for having hired the machinery at site, and it should have idled there. Insofar as labor is concerned, there may be payments that are required to be made. My lords, it's a railway overbridge. The place is very, very narrow, where if only when you can you'll have work is when you can deploy. There is virtually no space for them to keep anything there, and therefore, my lords, that is on facts. I am quite conscious that my lords may now not be.
They could not utilize it.
My lords, it's just lying idle for the purposes of this project, and that payments have been incurred. That is what is required to be established. Even insofar as overheads, I should have had a site and I should have incurred that expenditure towards employees. Insofar as labor and machinery is concerned, I would have hired a I would have hired a.
Generally, you know what happens. They say, look here, I have engaged them for this project. The project got delayed. I could not have removed them. I continue to pay wages to them, but there was no work. That kind of burnout.
My lords, the trend in these are one of. My lords, that is the way in which the claims are being made. That is what. Yes.
When a person is making a case for idle labor, what will he say? He has to say, this has to be constructed. They did not give me the possession of the area, could not construct. I had appointed in contemplation, the award having been granted to me. I have appointed people, they did not give it. I was paying every month to them, and that's actually.
I am at the last part of it, my lords, that I was paying. There should be evidence led that I have incurred that expenditure.
So what you are saying is the wage bills, everything needs to be produced.
Yes.
If they produce.
If they produce, my lords.
They produce. If they produce.
No, they have not produced. As I said, there are 6, 7 communications, 3 reminders. And those communications relate to something else. Now, my lords, when it comes to a case where we are claiming, it's not a case for nominal damages, that I'm not able to prove anything. Therefore, I'm entitled to some nominal damage. Now, my lords, this is a claim for section 70, under section 73, and with mathematical accuracy, numbers have been arrived at, without there being any cogent proof. There should have been some perusal of the bills, invoices, etc. Otherwise, if the principle of compensatory damage is to restore them to the place that they were, so they should have shown that the money is incurred. That is not there. Now, my lords, so now there are 3 contentions majorly I'll be canvassing, my lords. The first is that this is a case of no evidence. In fact, the first one will be section 16. And then it's a case that there is no evidence. And third, my lords, the issue regarding limitation. My lords, this is a case where, in a case where compensated damage, it would fall under Article 54. So when the breach occurs, I am referring to the judgment of the Honorable Supreme Court in Kothari, Kothari Associates. So as and when it accrued, such a so-and-so claim ought to have been made. Now, this is a case where 2014, my lords, the date was 5/2/2014 is when they completed the works. Final bill was not even submitted, my lords. Even according to them, final bill was submitted before the arbitration. On the date when the claim statement was filed, I'm sorry. 9/1/2020. 2020.
Oh, it is a work of 14 days submitted in 20.
Yes.
And the bill date is 9/1/20.
My lords, the
claim date is 5/1/20.
claim is 9/1/20 and the bill is also enclosed therewith. It is not, my lords, there is no date in the final bill. Not regarding the final bill. That is the interesting part, my lords. Yes. There is no date, my lord, as I said. There is no date. There is no date. It's set page number 132. No. The only issue that they refer to in their communication is, my lords, I am the executing agency for the release here, the PWD. So being the executing agency, they issued communications to me saying, please request because the contract has gone beyond 9 months, that the price adjustment ought to have been, originally the contract period was 9 months, because it should extend it. They said that please speak to them and request that price adjustment be allowed. That's all they said. That was the claim prior to that, my lords. But even after invocation, they can raise whatever other disputes that subsisted. But barring that, my lords, first the invocation is beyond limitation. Second is the final bill is submitted for the first time and the price adjustment bill for the first time before the tribunal in the year 2020. Now, my lords, insofar as Section 16 claim is concerned, my lords, Section 16, I filed an application saying that the Constitution is not in accordance with the agreement. On a particular date, I filed my application for Section 16 on the same day. In fact, it's recorded in the same order. I filed my statement of defense along with the preliminary objection that there is an objection under Section 16, and simultaneous herewith I filed the application. The tribunal comes to the conclusion that since I have filed my statement of defense, I am not entitled to maintain my Section 16 petition. In the order sheet, it clearly records. Now, may I draw my lord's attention to that paragraph? So, the order. Yes. The very same. In the statement of objections, the preliminary objection, the first preliminary objections was this. And in the same order, it records IA for Section 16 filed, the statement of defense filed, and on that ground, it stands rejected. No. The reason why I'm highlighting this, my lords, is that now when the award is being tested under Section 34, no amount of additional reasoning that they can provide to support the yes.
Jurisdiction of the tribunal. You say the procedure as is contemplated and the agreement not followed.
Yes.
That's the test.
Yes.
That is, after they had worked arbitration, gave you notice, you objected. They should have gone to those 6, what we call
institutional arbitration centers. No, they should have gone there.
And seek an appointment.
My lords, they have, yes, it will still be an ad hoc arbitration. It will not be in that institution because those institutions are the appointing authorities. They are the appointing. In one of the institutions, it's an institutional arbitration.
Not under the AD, under the rules.
It says the appointing authority is so and so. So it is left to the interpretation, whether it should be that. My lords, the difficulty is if it's ICA arbitration, my lords, it should be, they will nominate only if it is. Yes, so so few, in each of, there are 6 institutions, one of it is that also. So
this is your argument. But when you appeared before the 11th, did you take this objection?
no objections was filed.
So then why should we go into these objections in the court?
2 reasons, my lords. The scope of the Honorable High Court under Section 11 is to identify to see whether there is an arbitration agreement or not. And within that limited scope, my lord, there is an arbitration agreement admittedly in the contract. The scope under Section 16, my lords, would be to see whether the Constitution is in accordance with the agreement.
Right.
Whether so.
Right.
So
this 11.6 is not maintainable. The process which is being laid down under the contract has not been gone through. 11.6 is the last resort.
Yes.
All 6 are exhausted, then he will come to 11.6. Can you take that? On the maintainability of 11.6?
My lords, in fact, I've argued on this very same point because it's a standard KW4 document in another matter on the same objections. I will still reserve the liberty to go to the arbitrator because the scope is only
Not in this.
not in this. I have not appeared in this. It was before.
That will be that case. So my message
My lords,
in this very fact, see, otherwise you want to create as a further reason. No objection before the court below, before the High Court, you get an arbitrator appointed and mind it. Was there any observation by the High Court while appointing an arbitrator that you are able to see it works 16?
no, my lords, there was no such observation.
As good as saying, there was no objection from your side for appointment of an arbitrator, and the court has in fact appointed an arbitrator. The arbitrability is not in dispute. The appointment of an arbitrator is not in dispute.
May I persuade my lords in a slightly different way? Yes. May I persuade my lords in a slightly different manner? My lords, as I said, the scope before the Honorable Judge under 11.6 jurisdiction would be to see whether there is an valid arbitration agreement or not. Even assuming that the liberty is not reserved in my favor, insofar as other grounds that I could have raised, insofar as competence is concerned of the tribunal, on the grounds of whether it still survive. So irrespective of whether the liberty is reserved or not, my lords, that right would still subsist. So, my lords, it's a strange scenario. I completely, I'm with my lords. My lords, when the court adjudicating under 11.6 does not have the jurisdiction to see whether does not have the same jurisdiction as that of Section 16. No, my lords, it is it is not pre-15. It is 2019. 2019. Yes, notwithstanding the amendment. Yes.
Taken the liberty, did not contest, point one, all pleas were available. Otherwise, what were you doing? Suppose, let's assume you had the liberty under 16. You would have taken all the pleas which were available under 11.6.
My lords, those obviously I would have taken. No, on this, may I make one last submission? If, if at all, the 11.6 court exercising jurisdiction 11.6 had the same, was vested with the same jurisdiction as the tribunal would have had under section 16, my lords, that would be, my humble submission would be, that would be a scenario where I should have sought some sort of liberty to agitate that under section 16. So when the scope of 11.6 court itself is to identify whether there is prima facie arbitration agreement or not for the purposes of appointment, then my lords, the question of me seeking liberty or not having taken any such objections regarding the that would otherwise fall under the section 16's ambit would not, my lords, in my humble submission, take away my right to contest that ground in the arbitral tribunal.
It's not arbitrable. It's not that objection.
No, my objection is not on arbitrability.
Process has been contemplated under the agreement for appointment of an arbitrator. That has not been done.
Yes.
That's right. The fact remains, in terms of 11.6, there is an arbitrator who has been put in place. Right?
Yes.
So they are, so process may not have been undertaken for appointment of an arbitrator. The arbitrator has been appointed. Either you have taken all these objections of the process which is undertaken, which is laid down in the agreement at 11.6 stage, or you have taken the order of 11.6 in appeal. So today you will not argue. Be clear. At this stage, you can argue, see if there was a their order under 16 cannot be challenged under 37.
In a hypothetical scenario, if I may submit, that there are 3-tier system that is to be followed. Party autonomy, my lords. There is a 3-tier system, party have agreed. And the 3rd tier has not been exhausted. 2 tiers have been exhausted. The party goes before the invokes 11.6. My lords, when he invokes 11.6, all that he is urging the court of exercising jurisdiction 11.6 would be that there is an arbitration agreement, somebody needs to be appointed. The 2 facets of competence would be, my lords, under section 16. One is regarding arbitrability. Second is whether the constitution is in accordance with the agreement or not. Now, if the agreement is that XY, if they don't agree, B has the power to appoint the arbitrator, and the B has not been approached, then the constitution is not in accordance with the agreement. It also, my lords, it may overlap with that of 11.6 jurisdiction, because in 11.6, it would be a failure that will entitle them to go before 11.6. This also constitutes a failure. This also, the question would be that whether it constituted a failure or not. Now, it did not constitute a failure could be the argument that could be raised in 11.6. But at the same breath, my lords, it would also be true that the agreement said XYZ and that procedure has not been followed. Therefore, the tribunal is not in accordance with the agreement that the parties have. Because, my lords,
what prevented? If you can't at the 11.6 stage appointment of an arbitrator and mind it, okay, very good. You will not say so. In a way, you have submitted to the jurisdiction of the arbitrator appointed by the court. You may say, yes, I have submitted. Subject to just exception, I have a right under 16. I could still invoke 16. Can argue that. But in this fact, we will not.
In this fact,
has achieved. You did not go in appeal. You did not take objection. Think of that. You can take it. Then, had I been in 11.6, if you have taken, I said liberty is renewed to file 16. Then that 16 procedure would come. Obviously. And we do. And we appoint an arbitrator.
All issues are normally kept open.
When there is an issue of arbitrability raised, we say you raise it in 16. Raise it in 16. Okay, let's not go into this.
On section 16, my argument is different before this honorable court for this reason. That my lords are aware of the judgment, where it is PCCI's judgments, my lords, where it is more or less the law is settled that in section 34, what is to be tested is the reason stated in by the arbitral tribunal for rejection. For rejection of the application, for whatever reasons, for allowing or rejection of any claim. Any claims. That would be true even insofar as the section 16 is concerned. Now, the reason accorded by the arbitral tribunal cannot be, now my lords, neither me nor they can argue on the merits of section 16 that I filed or otherwise. Now, the issue will be confined to whether the reason stated by the arbitral tribunal is correct or not. If not, my lords, then what follows is the arbitral award may have to be set aside.
See, what follows, see, the arbitrator appointment must go. That's right?
Yes.
So the award.
Yes, so the award.
You are not agreeing with the answers. You are urging the same point, but on a different ground. See, you are lost. We say that he has summarily rejected 16. Summarily rejected 16. We will still read into that order that you did not take all these objections at level 6 stage. And mind you, there are judgments where people have taken objection to the procedure which is contemplated not followed. What the court had passed in orders, you will follow the process which has been laid down and then appoint an arbitrator. The parties would be at liberty to appoint an arbitrator. Failure to do so invoke 11.6. Yes. Failure to do so invoke 11.6.
But my lords, the difficulty here would be that I'll leave it to my lords on this. My last submission on this. Okay.
So see the claim which have been allowed. Do that.
Yes. May just point out for the order of the on 16. May just point out.
On 16?
On 16.
You have said
Just to
so.
go. Yes, I have said so.
The reason given.
The reason given is only one line, that you filed the application, statement of defense is filed, therefore your application is not maintainable. That is the reason. So therefore, my lords, my submission would be that now that he cannot say that, the 34 court ought to have looked at it. It cannot supplement reasons, my lords. That's
We are putting it to you. What prevented you to take all these objections? Find it. Was it your objection before the 11.6 court? This will tell you why. When this kind of a liberty is granted under 16, the first thing when you appear in 11.6 is this process which has been undertaken, contemplated, has not been followed.
that there is no failure.
So you are not on arbitrability, you are on the appointment of the arbitrator. There can be an issue. Can an arbitrator determine his own appointment? Let's put it. Secretary, what we are saying? Let's assume we have taken this point in 16. That the process which has been contemplated has not been undergone, and hence your appointment is bad. Can he say, my appointment is bad? Can he determine his own jurisdiction? Can he?
Because
Law is that's a law. The reference code, he cannot decide its own jurisdiction. You know, that's a judgments could have. That's another point to be deliberated. Whether you could have decided. If that's the reason, only on arbitrability, section 16 generally is properly invoked, not on the appointment of the arbitrator. In a given case, not in this factually. And you do not take any objection, nothing of that part. You allow the arbitrator to be appointed. You have not even sought any liberty that 16 be given, liberty under 16 be given to you. Even if 16 is given, we are putting it to you whether the arbitrator could have decided that his own appointment is bad.
my lords, according to there are two facets to section 16 in the sense. One is regarding whether the dispute is arbitrable or not, whether it is within the contract, etc. But insofar as whether constitution is correct or not, whether he has been constituted, whether he is a creation of the agreement or not, that would still lie with him, because that is again fall within the jurisprudence of competence.
It's not going to.
So therefore, my lord, it's actually, it overlaps in the sense that For 11.6, what is prerequisite is a failure. And here, that failure also forms the ground for section 16.
Let's assume he had the, he had the power to look into 16. He had the power to look into his own appointment, and the process has not been followed. The appointment is bad. He could have done it. Surely not in this case. Come to this, of course. Now comes to the claims.
Yes, my lords. May I refer to the few of the communications that have been exchanged, because I am not, my lords, I am not pursuing this honorable court to look into the merits of the evidence. All I am pointing out to my lords is, what is the evidence that is placed? Could this decision have been arrived at? Only for that purpose, I am pointing out what documents have been placed. It's very minimal, about 7-8 documents. That's all has been placed. In volume 1 of my paper book,
Yes, page.
my lords will see it. Page number 38 is the contract agreement. Then page number 84 is the notice to proceed. Page number 85 is the supplementary agreement. 85. Page 88 is the mark out date, on the date on which I have handed over the possession. Page number 89, my lords, is a communication that I have issued to them. Then page number 100 is a communication that I have issued to them. My lords, page number C7. C7 is where their evidence starts. C7 is a simple communication issued. It doesn't highlight any of these claims. This is after completion of the contract, wherein the request is made stating at the last paragraph, page number 101, the translated copy, my lords, can be found at 104. The estimated list of the said work is prepared by taking rates of the rate list in the year 2010-11. And markout will be given in the year, my lords, this translation is not correct. There's a difficulty. There's a difficulty that we face on a regular basis, my lords. The translations are Google Translate. No, we they do literal translation of word. It doesn't mean that. So this is one such letter. It is so. May I just read it in Kannada, and I will highlight. My point of limitation is
2014 contract completion certificate given.
12/12/2012 is the date on which the work commenced. I have handed over the date. 5/2/2014, neither party is in dispute that the works were completed. Thereafter, final bill not submitted, nothing transpired thereafter. He was persuading me, even as per C7, that request the railway authorities to allow price adjustment in this contract, because it my lords, there is price escalation, price adjustment. Price escalation would mean, in my lords, what happens is the quantities, certain quantities that are mentioned in the formula, if the amount, there is a certain fixed price. If the amount fluctuates, my lords, only if there is an increase that I stand to benefit. In case of price adjustment, it is either ways. It decreases, the price is adjusted to reflect the current SR value. So in case of price adjustment, there is a requirement that it should be there in the contract. In this contract, it is not there. But by virtue of a government order, my lords, if the contract, when awarded, is beyond a certain period of time, beyond 12 months, the price adjustment clause is to be incorporated. So now, originally when the contract was given, it is only for 9 months. Thereafter, it was extended because the works were not completed. Now the claim for price adjustment made by them is that this contract period is extended, therefore I am entitled to the benefit under the government order. This is their case. But what the government order speaks of is when the contract is awarded, you will have price adjustment if the contract period is beyond 12 months. So this price adjustment is done based on a formula. If it is not there, it is only as against the rate mentioned in the BOQ. Invoices will be raised and I will clear based on the completed works. So this would be the scenario. Now the price adjustment is in the nature of compensated damages in this case. This is the first communication issued by them, C7. C7, if I may read in Kannada, I'll just. Sadari Kamagari Andaju Pattiyannu 2010-11 ಸಾಲಿನ ದರ ಪಟ್ಟಿ 101 ಅಲ್ಲಿ ಕೊನೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಸಾಲಿನ ದರಪಟ್ಟಿ ದರಗಳನ್ನು ಅಳವಡಿಸಿ ತಯಾರಿಸಲಾಗಿರುತ್ತದೆ ಹಾಗೂ ಕಾಮಗಾರಿಗಳನ್ನು ಪ್ರಾರಂಭಿಸಲು 2012-13ನೇ ಸಾಲಿನಲ್ಲಿ ಮಾರ್ಕ್ಔಟ್ ನೀಡಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಕಾಮಗಾರಿ ಪೂರ್ಣಗೊಳ್ಳುವವರೆಗೆ ಸುಮಾರು 2012, 13, 14 ಮತ್ತು ಈಗಾಗಲೇ ಚಾಲ್ತಿಯಲ್ಲಿರುವ 2014-15ನೇಯ ಸಾಲಿನ ದರಪಟ್ಟಿಗಳು ಹೋಗಿರುತ್ತವೆ. ಕಾರಣ ನನಗೆ ನಿಮ್ಮ ಇಲಾಖೆಯಿಂದ ಕಾಮಗಾರಿಯನ್ನು ವಿಳಂಬವಾಗಿ ಪ್ರಾರಂಭಿಸಲು ಮಾರ್ಕ್ಔಟ್ ನೀಡಲಾಗಿರುವುದರಿಂದ ಹಾಗೂ ಇತರೆ ಅಡಚಣೆಗಳಿಂದಾಗಿ ಕಾಮಗಾರಿಯನ್ನು ಪೂರ್ಣಗೊಳಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಇದಕ್ಕೆ ಉತ್ತರ ಉಲ್ಲೇಖಿತ ಪತ್ರ 4ರನ್ವಯ ಮಾನ್ಯ ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ಗಳು ಸಂಪರ್ಕ ಮತ್ತು ಕಟ್ಟಡ ಧಾರವಾಡರವರು ಸದರಿ ಹೆಚ್ಚುವರಿಗೊಂಡು ಅವಧಿಗೆ ದಂಡರಹಿತ ಅವಧಿ ವಿಸ್ತೀರ್ಣ ಪ್ರಸ್ತಾಪನೆಯನ್ನು ಮಂಜೂರು ಮಾಡಿ ಕಾಮಗಾರಿಯನ್ನು ಪೂರ್ಣಗೊಳಿಸಲು ಸೂಚಿಸುತ್ತಾರೆ. ಈ ಹೆಚ್ಚುವರಿ ಅವಧಿಯನ್ನು ಸದರಿ ಮಂಜೂರಾದ 2010-11 ಸಾಲಿನ ದರಪಟ್ಟಿಯಲ್ಲಿ ತಯಾರಿಸಿದಾಗ ಅಂದಾಜು ಪಟ್ಟಿಗೆ ಮತ್ತು ನಾವು ಪೂರ್ಣಗೊಳಿಸಿರುವ ಸಮಯದಲ್ಲಿ 2014-15 ಸಾಲಿನ ದರಪಟ್ಟಿ ಹೋಲಿಸದಾಗಿ ಸುಮಾರು 1,83,00,000 ಮೊತ್ತವನ್ನು ವ್ಯತ್ಯಾಸವಾಗಿರುತ್ತದೆ. Essentially what he is saying, my lords, is the SR rates that were prevailing, the guideline rates that were prevailing when the contract was awarded, and on account of there being a delay and there being an extension, the subsequent 2 years price varied, and therefore I am entitled for a price adjustment. And therefore he makes a request that you make a request to the railway department, the last line. Madalu ಮಾನ್ಯ ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ ರೈಲ್ವೆ ಇಲಾಖೆಯವರಿಗೆ ಶಿಫಾರಸು ಮಾಡಲು ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿರುತ್ತದೆ. Communication regarding price adjustment, no other disputes are raised. Now the next communication, I only have 3 more communications that I wish to point out to show. Then is 15/4/2016. My lords will note that there is no bill enclosed even here. It's a request made saying that you please persuade the railway department. Then is C8 at page number 106. This is another communication to the same effect. C9, another communication, my lords, wherein the same ground is raised. And then C11. Now, in this, there are certain other claims made. This is in the year 2017. In the year 2017, he lists out about 9 claims: idling of machinery, equipment, centering materials, increase in price of steel, etc., etc. This is just a communication. No receipts are produced. Then my lords is 15/2/2018 when the arbitrator was appointed. Then my lords will see that there are communications regarding appointment of arbitrator. And then there are 3 calculation sheets. One is the final bill at page number 130, which doesn't have a date. It's from page 130 to page number 147. Then is another calculation sheet, annexure 3. This is insofar as price adjustment. This they call it the bill. This is again submitted for the first time before the arbitral tribunal. Then 3, this is the document, page number 180. Page number 180. There is a list of machinery given here. Number of days of idling is shown, hiring charges are shown, and according to them, there is an expense incurred for 4